Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, Mr. Isley, you may proceed.
Thank you, Your Honor. Good morning, Your Honors. May it please the court. My name is Justin Isley, and I represent the appellant, Stephen McGrath. Mr. McGrath is not here to appeal his conviction. He is merely asking this court to review two sentencing arguments that have substantial constitutional and fairness implications. Considering Mr. McGrath's arguments on their merits is not only legally correct, but doing so lends greater certainty and clarity to the criminal justice process. Our criminal justice system has been and is still sending people to prisons at rates that were not foreseen by the founders of this country. Jury trials are drying up, and powers in our judicial system has largely been consolidated to the Department of Justice. The threats of mandatory minimums and sentencing enhancements that are outside the federal bench's control have led to very little exercise of a defendant's constitutional rights over the past 30 years. Review of these claims will cause no meaningful harm to the government, considering their limit and scope. My client raises 2 points in appealing his sentence of 22 years. First, Mr. McGrath argues that his due process rights were violated when there was an impermissible consideration of religious principles in his sentence by the sentencing court. During the sentencing, the judge made references to the soul dying and equating it to murder at the sentencing proceeding. In addition, mentions a religious phrase, "But for the grace of God."
Don't you have
all of us.
Question as to your appeal waiver in the plea?
Your Honor, that's a good question. The government, this case is a little bit unique procedurally, and normally in my practice, as we do quite a few of these appeals, we're on the panel, the government will file a motion to dismiss based on the plea waiver. I don't know that they're procedurally barred at this point because they do raise it in their brief. I do believe that the question comes down to whether there's a colorable claim of due process. If there's not a colorable claim on the merits, then we're back to square one. I don't have an argument on this point. But if there is a colorable claim, I do not believe that this court and other courts have enforced appellate waivers when there's a genuine issue of due process violation, such of the nature that we have raised. Again, if the court disagrees on that point.
Excuse me, why your position is that you can simply slap on a boilerplate allegation of due process to any sentencing error that you perceive. These questions are evidentiary questions and all the rest, and I just don't. If you can make a constitutional error out of this sentencing proceeding, and I would think you could make a claim of constitutional error as to any sentencing proceeding, and the whole value of plea waivers, appeal waivers, which often work to the defendant's benefit, likely to be lost.
Well, Your Honor, as to the boilerplate language, respectfully, this argument is based on the words of the trial court, and the argument that this is boilerplate is not boilerplate language that I use in any of our briefs, and I don't see it too frequently. It's a serious argument to make, alleging an infringement of a due process right, and it's not made lightly. But it was something that was perceived by counsel and my client, and to the extent that this has implications about the appearance of the trial court imposing a sentence based on the guidelines and the factors well, more specifically, the factors is important to address on the merits because we do not argue this in a boilerplate manner. It's strictly based on the principles set forth in the precedent of this court and the Supreme Court. The decision of the trial court should not be made based in any way on religious principles. And the court says that the reviewing standard is whether or not this religious principle or any other ones unduly influence the sentence imposed.
But counsel, this is Judge Keenan. But you're not challenging your appeal waiver, are you? I didn't see anything in your submission that suggests that you're saying that the plea waiver is invalid. Is that correct?
Thank you for the question, Your Honor. We are not arguing that there is not an appeal waiver that is part of the plea agreement. The argument is, well, and I can address these. We have two arguments on appeal. The first argument is that a due process violation of this nature does not fall within the scope of that waiver.
Okay, could you point us to the language then in the appeal waiver that suggests that your current argument is outside its scope?
Well, I would go back to the cases, and these things are reviewed for essentially on a contractual basis about consideration. And the difference between the contractual type review here is that defendants are given some deference because they're not quite in the same position as those in normal contracts, and because of the type of seriousness here. I would argue, Your Honor, respectfully, in the opposite. There's no provision here that says that he waives his right to be sentenced by a court that doesn't consider religious principles. Again, I understand the court has to make a decision whether or not the comments in the court proceeding rise to that level, but just as a matter of public policy and the literal language of the waiver, if it's not explicitly included, then it should not fall within the waiver that my client signed at the sentencing.
Okay, well, my concern was with the language in the waiver that says waiving any constitutional challenge to the calculation and imposition of any term of imprisonment. And so if you could tell me how you get beyond that language, that would be helpful.
Right. In the language of that is the constitutional challenge of the calculation of the sentence. I don't read that language to be
calculation. Excuse me, Counsel, I didn't mean to interrupt, but it's calculation and imposition of any term of imprisonment. And I didn't know if you had that language in front of you. It's both calculation and imposition.
Yes, I do have that language in front of me, Your Honor. And I would point to I do see that language in the argument. I would point to the fact that this court has addressed substantively constitutional challenges where the sentencing court has made religious arguments in sentencing, and the policy implications for a client to waive a challenge to a scenario where a sentencing perhaps was completely and wholly based on a judge's religious principles, whatever they may be, is not foreseeable to a defendant when he enters a plea waiver at his plea hearing. So if that would be to the rule, a sentencing court could explicitly and only mention Bible verses in the sentencing, and that would not be permissibly reviewed because of the appellate waiver, and the consequences of that would be devastating to the credibility of our judiciary. And respectfully, the type of fundamental protections from intrusion of religion into all facets of our government are important, and to that extent, that type of application to an appeal waiver is problematic. because that would allow for any religious statements would be above review when a client signs a plea waiver at his plea hearing, not knowing what will happen at the sentencing stage.
So, counsel, this is Chief Judge Gregory. You're framing this as this is a question and not a comment, but it's a question. You're framing this as if this is similar to, I know you don't want to use this word, but similar to sentencing you for improper reason, like that example. Would you say that the court is not allowed to sentence you for an improper reason, mainly for religious type based? Is that what you're saying? Why you're outside of it?
That is correct. Either race or religion, any of those fundamental purposes. I think if the court were to enforce this appellate waiver on this issue and not reach the merits, a trial court could also base a sentence on race. And it would not be reviewable by this court. And so I think there's a lot of just very practical problems with not addressing it on the merits. And again, these types of, I'm sorry, Your Honor.
Yeah, I follow that. That's why I thought that Judge Wilkinson asked you a very good question, because he's actually right. If this is just a garden variety procedural problem, then everyone would be get around, like he said. And Judge Keenan, likewise, in saying what is left that would be outside. But yeah, that's what I thought you were saying. It's it's an improper reason, just like it would be race or sex or anything else. But here's the other question that makes it difficult. Because it's not garden variety, it is specific. What do you point to in this record will show that the court demonstrated any animus as to religious practice of the judge or your client that impacted that level of improper sentence basis? Can you point to that? I mean, so far you have the reference to things like "but for the grace of God" and some references to soul and those things. But what level do you have in the record that would be evidence improper basis or animus, or that we could say that would be, as you write, would be detrimental to our system of justice or anything like that? What do you have for that?
Yes, Your Honor. I appreciate the question, and I do credit the government for bringing out these other cases. And essentially the argument is, in other instances, this court and other courts around the country have seen arguably stronger language, more mention of religious principles in the sentencing, and still upheld it. As I mentioned in my brief, the standard is, did any of these religious principles, or if it were race, were these influencing factors in the sentencing?
Oh, this is the thing, to the degree that they worked in any direction. And I don't think that they did. It didn't seem to me that this was a religious kind of sentence, but to the degree that they worked in any direction, they worked probably in your favor, in the direction of mercy. And the guidelines recommended life imprisonment, and your client received from Judge Grimm 22 years. And to the degree that there was any reference to the spirit or the soul, that worked in your favor, and I wouldn't think that we would want to eliminate mercy from sentencing proceedings. A lot of defendants deserve mercy, pure and simple, and that's why the guidelines are advisory. They're no longer rigid. But the constitutional claims seem to me to be such a stretch, frankly, that when we get a so-called constitutional claim that is such an incredible stretch, I wanted to come back to Judge Keenan's point. That would seem to me to bring it within the scope of the plea waiver. And once again, the plea waivers are an important part of plea bargaining. You may not like them, but many times they work. The plea waiver, it can be a significant factor in reducing a defendant's exposure and sentence. And so it seems to me you're working against the interests of defendants in both of these ways. One by vitiating the plea waiver, and the other by taking references to grace and mercy that work in a defendant's favor, and you're saying that's impermissible. And what you're doing is you're taking the element of compassion out of sentencing hearings, and that can't be right.
And Your Honor, I do definitely appreciate the court's concern about preserving the issue of mercy and leniency. However, the religious phrase that was mentioned is specifically Christian and more so Protestant, but it is a Christian verse. And mercy does exist within the factors of 3553A through the characteristics of the defendant and all of the factors. And
more than offhand remarks.
I certainly appreciate the point of view of the court. It was something that was noted by this trial counsel and my client, and to the extent this court reviews these things, I guess the question becomes the language of this court is whether or not this point of view influenced the trial court, and did it influence the punishment. And I heard Your Honor mention that you believe it actually inured to my client's benefit. However, on the kind of the other side, the mentioning of the killing of the soul is essentially the same as murder, actually cuts against my client, because it was equated essentially that these types of crimes are, because of the nature of them, are essentially can be like a homicide. And so when you have religious principles that talk about soul or biblical verses or any kind of religious text, it does call into question and some doubt into the person who's standing there being sentenced. Again, someone being sentenced definitely wants to have mercy considered, rehabilitation considered, but these should be not religious principles. They are human principles. They are principles that are available to the sentencing court under the statute. And it's important for our justice system, especially as we become more diverse, that people that are in front of the court can feel that it's based strictly on the law and not any, even if sometimes or mostly well-meaning religious principles that kind of invade that decision making. But I do again appreciate Your Honor being concerned about mercy being swept out of our system, because it is an important principle under the law. And I would like to, forgive me, this is the first time doing this type of remote argument. I may be losing track of time, but I did want to address the procedural issue with the second argument, since it was such a contested issue on this constitutional claim. I know it's a concern of the court on this procedural reasonableness claim. And as I mentioned in the reply brief, I normally get a motion to dismiss after the opening brief, but it was actually in the responsive brief. So in my reply brief, I bring up the issue of whether or not this court should address the procedural reasonableness of the sentence. Mr. McGrath was already at the high end of the guidelines. Therefore, the court actually, normally, I know the court has reviewed these plea agreements and the waivers, is that if it's above a certain guideline level, well, then the defendant can appeal. If it's below, then the government can appeal. But on the nature of this plea, there was nowhere to go above. So essentially, there would be no guideline calculation that reviewed that could have allowed for any kind of appeal. And as mentioned in the paper that I listed in my reply brief, this court should consider the consideration that's given, asking this court to consider the consideration given at each portion that it relates to something. Did the defendant give up something? Did the government give up something? And respectfully, there was never going to be a situation where Mr. McGrath could have appealed his sentence because he was already at these astronomical lifetime sentencing. And so because there's a lack of specific consideration, we would respectfully ask the court to consider the merits of the procedural reasonableness arguments, specifically because it's so important as we move to a more science-based or data-based sentencing. At sentencing, we raise several statistical arguments that come not from way out there sources. They come from the federal government's own statistics. And as this court is aware, sentences for sexual offenses have been astronomically rising year after year. And that's not under the control of the judiciary, but this is it's a very serious issue. So we would ask that if we are going to move to a more science-based decision-making process, that statistics be considered, because that was one of the founding principles of the guidelines themselves, is that they took this data to try to make sure that sentences were not disparate and they were fair for like persons. And if well-founded statistics are dismissed so quickly, it's going to affect the integrity of these sentences and the appearance to people that are being sentenced.
You've covered all that in your brief.
Yes, and I would just reserve whatever time I have left for rebuttal, please. Unless there are questions.
Thank you, counsel. Mr. Baldwin? Hello?
Sorry, Judge, trying to unmute him, but he's not. I don't know why the conference isn't letting me unmute him. Mr. Baldwin, I'm going to hang up with you and I'm going to call you back, okay? It's not letting me unmute you. Judges, I apologize. It won't let me do anything.
You deserve hazardous duty pay for this, Rachel.
I appreciate that, Judge. Let me see. Let's try calling him again and see if it... Okay.
If you would like to go ahead, Mr. Baldwin, and continue, I'm going to go ahead and mute this line now, okay? Judge Gregory, is that okay?
Sarah. Thank you.
Thank you
so much. Yes,
okay, thank you.
Bye-bye. Mr. Baldwin, you may proceed.
Thank you, Your Honor. May it please the court, and just for the record, I heard Mr. Isley's argument to completion before the phone cut off.
Thank you.
Thank you, Your Honor. My name is Joseph Baldwin. I'm Assistant United States Attorney in Greenbelt, Maryland. I want to address first, right off, Your Honor, the notion of, I think a key notion here, which has to do with the waiver. At JA 180, Mr. Isley writes in the sentencing memorandum that the prominent benefit of the bargain in this case was that in exchange for a plea, a count of production of child pornography would be dropped in exchange for a plea to solicitation of a minor, along with a simple child pornography possession. And he notes that the original mandatory minimum was 15 years, whereas the minimum with the new count, which was the one that he pled guilty to, was 10 years. And that is the benefit of the bargain that Mr. Isley was just mentioning. There was, in fact, a consideration given for the waiver of plea. And in fact, what the defense did was trade a mandatory minimum of 15 years with a maximum of 30 years for a mandatory minimum of 10 years with a maximum of life in prison. And I presume that the calculus for that was that he was more likely to be able to pull a sentence down and wasn't as concerned about the top end. And that's, in fact, how it played out in the court. And so there was a serious benefit to the defendant here. He was well aware of the plea waiver and the resulting potential for a offense level 43. There's a specific discussion of it at JA 49 in the transcript. The judge touched upon the fact of a offense level 43 claim. Basically, the defendant was giving up a right to appeal because any sentence up to life would be within that offense level, although the government did retain the right to appeal. And so there was a benefit of the bargain here, and the late argument in respect to the reply brief with respect to procedural reasonableness is just not based in fact. With respect to the notion of how this fits into the plea waiver construct and the case law that's been set forth there, as Judge Keenan noted, I don't think there's any assertion here that the waiver is invalid. It is valid based on the plea agreement itself and also based on the colloquy that was in court that really hasn't been challenged. I think that the place where this case goes to the scope question. And really for the government here, it seems very clear that this type of challenge is outside the scope of, is within the scope of the plea waiver. It's not in one of those narrow exceptions that would be outside the scope of the plea waiver. And the court has dealt with this in a long series of case law, including the Thornsberry case that was cited in our papers. And it addresses this. And in fact, it addresses what the chief judge noted was that if you create a constitutional claim, so to speak, can be done in almost every case. And if you view that as being illegal, for instance, as how it was looked at in the Thornsberry case, and Judge Duncan there reviewed that the term illegal has been used in the specific context of plea waivers where the sentence is alleged to have been beyond the authority of the district court to impose. So there have been instances where a judge has been found to be acting outside the boundaries of authority, for instance, orders sex offender registration where there was no authority to do so, or orders restitution where there was no authority to do so, in similar cases. There's also another bucket, if you will, of things that could be illegal claims. For instance, the one that's mentioned the most in the case law is claiming that a sentence was based on a constitutionally impermissible factor, such as race. I'll return to that in a moment. And finally, claiming that a post-plea violation of the right to counsel was an issue. So the question becomes, is just any claim that has some constitutional or alleged constitutional aspect to it, therefore sufficient to get past a plea waiver? Well, this court has found that that's not the case. For example, in the Dalzell case and the Ballard case that were cited in our papers. And what appears to be happening here is something that the court has noted before in other cases. For instance, I believe in Blick, there was a footnote that talked about there's a validity step and the scope step. And in the scope step, it looked like that the possibility or a miscarriage of justice seems to be subsumed within the scope portion of the consideration. So that the Fourth Circuit has built this miscarriage of justice aspect into the scope aspect. And miscarriage of justice is a very high standard for getting to the realm of getting past a plea waiver. And I think that a miscarriage of justice analysis, which is phrased in our brief as a colorable claim, you have to, and one of the problems with the notion of colorable is that it's a metaphor, and so the question is, well, what is colorable? Is it a pastel or is it a jewel tone? And the government submits, Your Honors, that in fact, in practice in the cases, that it has, the court essentially looked at what the appellant has put forward and has, looked at those things and said, well, this doesn't get there in this instance, and so we're not going to waive the plea waiver. It's totally within the plea waiver, even though the appellant has argued that there's some sort of constitutional aspect to the claim. And there have been instances where a plea waiver was set aside in order to get at something more specific. For instance, in the Attar case, the court said, well, we're not going to hold the plea waiver. We're going to consider this outside the scope because the defendant has alleged that he was deprived the right of counsel at sentencing. That was looked at and considered. Ultimately, the court found that if the defendant essentially constructively dismissed his attorneys at sentencing in such a way that it would have whipsawed the judge, and the underlying constitutional argument he made there was considered under the validity prong. But essentially, that's where the notion of this colorable analysis came from. And in that footnote 2 of the Attar decision, it talks about sufficiently colorable. And that's where I'm talking about. It's not just merely any argument that there's a constitutional connection would apply. So that's where I believe we are in the framework of the court, Your Honors, and let me explain why the government doesn't believe that on the facts that are presented here that the defendant has or the appellant has met the obligation of putting forth enough information that would result in finding these facts are outside the scope of the plea waiver. And it's very straightforward. The first claim in this appeal has to do with the statistics aspect of this, which goes to essentially whether it was procedurally, whether the judge considered arguments that were made in mitigation and sentencing, arguments that were made that should be considered with respect to the defendant's culpability and the factors under 3553A. In the ordinary course, this is the type of guideline consideration and proceeding within sentencing that would be within the scope of the waiver. There's many cases, for instance, the general case in which some items were set, the government did not even entertain the notion that it would challenge it in terms of scope. And in that case, for instance, there were a couple of claims, one that had to do with Apprendi, and another one had to do with competency, and the government didn't argue that those were things that would be subject to the waiver, but there were three issues that would be subject to the waiver, and they had to do with how things were considering at the hearing itself, guidelines, calculations, and things of that sort. This claim with respect to statistics is in the first sort of those categories. And as a factual matter, in this instance, Judge Grimm did consider the statistics. He noted that the statistical studies that had been asserted were all over the place, and he also even couched it in the terms of, I don't know whether you're the 95% of people in your situation that don't recidivate or the 5% of people who do, and I can't really know in an individual instance based on statistics, and which is a truism. But the judge also acknowledged that he had looked at Dr. Berlin's report, considered it very heavily, and Dr. Berlin issued a report that said if the defendant is properly treated, then the chance of recidivation is very low. It's obvious that the judge considered those things, and in fact, he said he considered those things. But ultimately,
your view is we don't need to get into this.
That's correct, Your Honor. And that is sort of the
merits claim.
Sort of the mind run of. Yes, Your Honor. Secondly, and I'll move on to the second merits claim, Your Honor, which is the one that is has been asserted to have this constitutional aspect. And Your Honor, I think the appropriate analysis in this case is similar to another case. I believe it was the Dalzell case. In that case, the assertion was there was an argument that a defendant's prior confession to a murder that had been rejected by a state court was accepted by the federal district court in the sentencing, and the defendant asserted that confession was compelled and wasn't actually confession at all. Was against Fifth Amendment rights of the defendant. But in that case, the court found that there may be a case in which an unreliable statement was beyond the scope of the appellate waiver, but essentially that case, the Dalzell case, wasn't one of them, and the circumstances haven't been shown. And I think that's exactly where the court is in this case, and should be in this case, Your Honor. Here, the defendant put his best foot forward, cited the Baker case. But in Baker, as a legal matter, there were two things. One was it was a judge that expressly identified with a religious group, expressed a religious orientation with respect to the facts of the case, A, and B, then punished the defendant with respect to that, or there was appearance of a punishment of the defendant in reaction or with that identification in mind. This case is nowhere near that. In the context of the colorable metaphor, but there's not even a pastel here. We don't get to the first step. There's not the identification with a religious sentiment such that the judge, and furthermore, there is no action based on religious sentiment. And therefore, Your Honor, is based on the fact that this doesn't even get to certainly doesn't get to a miscarriage of justice. There's been no showing of a miscarriage of justice, and there was the potential, perhaps, that this would be a case in which there's an impermissible factor like race that was considered. But once the facts are put forward by the appellant, as they would have been in a response to motion to dismiss, so I don't think that's really an issue here. Once those facts are put forward, the court can see that this is not the type of case in which the facts have been found to be outside the scope of an appellate waiver, and therefore the appeal should be dismissed because the waiver still operates against both the arguments that are made by the defendant and the appellant.
Well, it pretty much covers it.
Thank you, Your Honor.
Mr. Eisner?
apologize, Judge. I'm trying to unmute him. It won't let me. It won't let me unmute him.
It's the same problem.
Rebuttal time.
Sure. Go ahead, Ms. Isley. Sorry for the time.
No problem. I appreciate everyone's patience. Could I ask if I did not know how much time I had left? I wanted to be brief, but I did definitely.
Well, we know you reserved 7, and we still have 7.
Okay, I'll proceed. Thank you, Your Honors. I listened closely to, and I was able to hear government's argument, and I come back to the point that if there are the decision of this court in reviewing a claim for impermissible reasons such as religion or race, I don't know how this court can parse that out, and if the conclusion is that it is contained within the appeal waiver, then the consequence of that decision is that these claims are not reviewable. If the court does consider the merits and says that this review of the record shows that it's not a colorable claim, then that seems to be the more prudent route that will not forego someone the ability to review a case if they make a claim based on religion or race. Just as a practical matter, this is not an issue where government a lot of times will state they will be inundated with numerous appeals if something like this is allowed. I myself and my partner filed many cases with this court, and we reviewed most of the cases that come out. And these are not very common claims at all. And so to the extent that there is a concern that this will lead to an avalanche of litigation, I just don't think it would be borne out by the types of cases that this court receives. So we are asking the court, because of the serious nature of ensuring the credibility not only to those observing the proceeding or participating in it, those who are subject to it, that the court render a decision based on the merits of the claim. With respect to... Yes, Sean.
This counsel, for example, see what you're saying, but in this case, in the facts, didn't you open the door about homicide by comparing the sentencing in homicides to sentencing in child pornography cases? And you could say that the court was juxtapositioning your point to, well, in fact, these victims suffer a type of death. Did you open that door?
I do. I don't have that section of the record in front of me, but I do definitely remember making that argument.
You should know the record better than I do. Did you make?
I do. I do. I remember my own. Yes.
And you did it in a sense of irony. You did it in a sense of irony, and that's you did. And so you opened the door, didn't you? And that the judge was trying to address as he's supposed to your arguments, and you made that as a non-frivolous argument, didn't you? Did you?
I did. Yes, I did.
But if you made it,
sure did.
Well, made it as a non-frivolous argument, then the court is obligated to address it. And he addressed it by saying, well, I'm not sure, counsel. When you have victims like this, they die sort of a slow death. It's an internal one. You may say soul or internal. I think in this case here, you're talking about things that really aren't referencing preference or animals in terms of race, religion. Instead, it's dealing with a philosophical sense of the nuances of human experience that you raised and that are important in sentencing. So I'll get you a point that if someone says something over the top, like it was adjudicated in the cases in Baker, but this is not that case. And as Judge Wilkinson said, the point about there go out by the grace of God, it was to your favor. He was saying that all of us do things that are difficult and wish we had, and it may be life-changing situations. And so to say that this type of record would suggest the animus and the constitutional problem that you talk about and that you want us to broadly address in this case, I see what you're going to. This is not the case, counsel. Is it?
Your Honor, that you've made very good arguments, and I certainly have made that argument.
These are not arguments. I don't have my days of argument over, and I practice law.
I'm sorry. The point that you bring up, Your Honor, is I apologize that I've spent too long in the arguing around, but I hear your point based on what I said at the sentencing, and I would just go back to similar to what I had previously said in my opening, is that it was certainly fair to come back at my point about the way we treat these sex offenses in the federal system, and to make points from the bench that show these are the types of things that make this serious. For example, the trial court was at length mentioned psychological harm, the court's experience in reviewing kind of what happens to the victims. There were victim letters that, were substantively, they themselves shared these harms that happen that are not short-term. They can definitely be and are long-term. But the mention of the soul is not required. And I get the kind of mentioning of that. It's to make a point, but these points that are made in this way point to the idea that there is a manner in which the court is viewing the events that are happening before it in a non-secular way. And is it nearly as overt as the Baker case? Of course not. I've not tried to compare this factually directly to the Baker case. That was over the top. But there are clues that are given by people that make decisions as to what guides them. And certainly people have a right to be guided by certain principles. But if they fall outside what is mandated by Congress through 3553A, I think the court should strictly review these types of situations to ensure credibility to those that are being punished, so that they know that what they are being sentenced for are permissible factors and not based on the sentencing court's view of the world through a religious scope. And it's important for the credibility of the judiciary as we become more diverse, and that's where the argument lies with respect to that. And I think that the argument on the procedural reasonableness as to the specifics has been made fully, and I appreciate the court for their time.
Thank you so much, counsel, for your arguments, both. I note, Mr. Isley, you were court appointed, and I just want to say, give a special thanks to you, because our court depends upon lawyers like you who take these cases and argue the cases as you've done very well on behalf of the client. They're very important to the court. We thank you. And obviously, Mr. Baldwin, we also thank you for your able representation of the United States. We can't come down and shake your hand, but know that the sentiment and the expression is just as intense of our gratitude for your being here. We ask you and hope that you'll stay safe and be well. Thank you, counsel.
Thank you, Your Honor.
The court will take a brief recess before hearing the next case. Judges, I'm going to
morning.
Good morning. Good morning. You may proceed.
Thank you. Good morning, Chief Judge Gregory, Judge Wilkinson, and Judge Keenan. And may it please the court, I'm Theodore A. Howard on behalf of the appellants, and subject to such questions or concerns as the court may have, I will address three questions. First, whether the district court erred in concluding that its evaluation of appellants' claim that they were denied adequate mental health care in detention at Shenandoah Valley Juvenile Center should be governed by a deliberate indifference substantive standard rather than a professional judgment standard as articulated in Youngberg versus Romeo. Second, whether the district court, if the district court did err in failing to apply the professional judgment standard, whether trauma-informed care constitutes the consensus standard of care among professionals in the field of treating mentally ill children in a juvenile detention setting, by which the judgment reflects.
This meeting is being recorded and/or transcribed.
By which the judgment reflected by Shenandoah's treatment should be evaluated. And third, and arguably most critically, whether, even assuming that the district court correctly applied the deliberate indifference standard rather than professional judgment, summary judgment in favor of Shenandoah on the inadequate mental health care claim was nevertheless improperly granted in light of the facts of record, viewed in the light most favorable to plaintiff John Doe 4, and with all reasonable inferences from those facts drawn in his favor. Regarding the governing standard, the parties generally agree that the fact-specific functional analysis articulated by this court in the Patton case is determinative, considering both the basis and rationale for the detention and the nature of the detention facility.
Let me ask you a preliminary question. Under the cooperative agreement, the center, it provides the detainees with housing accommodations, food, clothing, routine medical and dental care, weekday classroom education, recreation, access to religious services. I gather there's no question about the provision of educational or religious services or food, clothing, and routine dental care, for example, or medical care. There's no question that the center is not providing those. Is that correct?
Judge Wilkinson, I believe the correct answer is that there is no question that the center is providing those, at least for purposes of this case. There is no claim with regard to inadequacy with respect to any of those matters.
Okay.
Our position is that the statutory scheme governing ORR's custody of unaccompanied minor immigrant children, as well as the contractual provisions of the agreement between the Office of Refugee Resettlement and Shenandoah, both point to the conclusion that Shenandoah is more like the treatment facilities at issue in Youngberg and Patton, and less like the criminal detention facility involved in the Newbrow case, upon which the appellant and the court below largely relied. By statute, unaccompanied minor immigrant children are to be placed in the, quote, least restrictive setting, consistent with their best interests. They may not be designated for detention in a secure facility such as Shenandoah, absent a determination that the child poses a threat to themselves or others, or has been charged with having committed a crime. And here I would note that there does not seem to be any dispute that the unaccompanied minor immigrant children confined at Shenandoah were there due to behavioral issues, not as a result of criminal activity. The secure facility placement must be reviewed and reevaluated on a monthly basis to determine if such restrictive placement remains warranted. And finally, in any event, the facility must be, quote, capable of providing for the child's physical and mental well-being, unquote. The concern is that if a child is sent by ORR to Shenandoah, a secure facility, on the basis of mental health-related behavioral problems, and as Shenandoah contends, it essentially has no obligation to provide other than very basic mental health treatment, then the 30-day review and the prospect of a child in those circumstances being, quote, stepped down, unquote, to a less secure setting is pretty meaningless, because if there's no treatment, there's no opportunity for the child to get better. And therefore, we contend that this is a treatment.
Excuse me a second.
Sorry.
You made a statement about there being no treatment, but as I understand it, that's not quite correct. I thought the record reflected the fact that there were two clinicians and a psychiatrist gave treatment to Doe, and he was regularly seen by the clinicians at least once a week, and the clinicians, the mental health clinicians, were their names were Andrew Males and Evan R. Ailman, and both of them were licensed professional counselors. They both had master's degree. They'd each completed 3,400 supervised clinical hours, and that wasn't all. He was receiving mental health treatment from Dr. Kane, who is an outside psychiatrist who visited the facility and apparently met with Doe whenever he visited. Now, I understand you don't, you think that's not ideal, but to say that there's no mental health treatment when you have two clinicians and a visiting psychiatrist. I realize you think that the visiting psychiatrist didn't meet with him long enough, but there is mental health treatment that seemed to me so different from the payola. It may not be ideal from your point of view, but for a facility which isn't set up as a hospital, he's been doing pretty well. I mean, and they have, he's been able to, the clinicians, whenever he's wanted, he hasn't been cut off. There is a large number of visits with Dr. Kane, and actually the mental health that he received, by his own admission, that his anger management improved while he was at the facility, and they, except for one incident, they kept him, for the most part, from self-inflicted harm. Medications were prescribed. All I'm saying is that if there was no mental health treatment, and if he was just being warehoused, that might have a stronger case. But here we have a situation where there's no question that some treatment was provided, and the matter is whether it's all that you think should be provided. But this is it is provided seemed to be far more than negligible to me.
Your Honor, if I may respond to that, there is a fundamental question here as to whether or not the mental health treatment provided, such as it was adequate, constitutionally adequate, as required by the Delonta case, etc. And the critical problem here is that the testimony and evidence provided by Shenandoah's own employees basically casts significant doubt on the adequacy of what they were doing. There isn't any question that...
Excuse me, Mr. Howard, this is Judge Keenan.
Yes, ma'am.
Mr. Howard, and I don't mean to cut off your answer so early in your response to Judge Wilkinson, but perhaps you could also frame your answer in the context that if we agree with you that the professional judgment standard under Youngberg should apply, isn't this a matter to be remanded to the district court in the first instance to go over the adequacy of treatment? Because the district court specifically excluded portions of Dr. Lewis's testimony. We don't even have a complete record in front of us. So I wonder whether the adequacy of the treatment, if we agree with you on the professional judgment standard, is something that necessarily needs to be considered on remand. So if you could take that into consideration when you're giving further answer to Judge Wilkinson.
Yes, Judge Keenan, I'll try. Because we do believe that adequacy of the treatment, such as it was, is a question under either the professional judgment standard, which we contend should have been applied, or under the deliberate indifference standard. With respect to professional judgment, we do believe that the way in which Shenandoah was charged with functioning with respect to these unaccompanied minor immigrant children, with regard to its obligations to provide adequate mental health care, both under the statute and under the contract, does indicate that it was functioning as a care provider, quote unquote, for purposes of these children, irrespective of its function in other contexts and capacities. The weekly individual counseling sessions, the group therapy sessions that were supposed to have been held, and the meetings with Dr. Kane, there are clear questions with regard to the adequacy, whether or not under the professional judgment standard, which we contend should be informed by a trauma-informed standard of care, or without regard to a particular standard of care, just adequacy in the abstract under circumstances in which the clinicians themselves said that they don't treat or even discuss trauma with children, that even when they're provided with specific treatment directions or recommendations on a particular child from a psychological evaluation, that they do not provide.
Counsel, excuse me, when you keep coming back to the adequacy of this and that, I have a question about the Youngberg standard is one that draws us maybe into adequacy, but more so than the deliberate indifference standard, so I understand why you want that standard. But the whole question of adequacy seems to commit us court to a long-term institutional supervision of this facility. And the Supreme Court, more and more, has indicated that it's really not a proper function for federal courts, or it's a very sparing function for federal courts to be institutional supervisors of schools, prisons, mental health facilities, whatever you call it. We really don't. We can, of course, rely on experts, but we really don't have the kind of expertise that can be used to make informed assessments of these kind of things. There's a limit to which we can play mental health clinicians, but I am concerned about the warnings from a standpoint of federalism and others of placing the federal courts in an institutional governance role and committing us to continued supervision of something in which we have limited expertise. And oftentimes the Youngberg standard has been applied in the case of an individual and individual circumstances. But here, Doe 4 is a named plaintiff, and this is brought in the context of a class action. And when you bring things in the context of a class action, then we're supposed to assume institution-wide responsibilities. And I wonder if we're not overstepping our appropriate role.
Judge Wilkinson, I don't believe so. I believe that under the cases that this court has previously decided, including Delonta, DePaola, etc., that constitutional adequacy of care is an element of a deliberate indifference analysis. And when the facility's own people, those who are actually providing the care, have expressed clear concerns about the adequacy of what they're doing in light of the needs of the children that they're purporting to care for, at a minimum, there are significant questions of fact that should have precluded the district court from finding as a matter of law that the mental health care was adequate. It would be one thing if... Yes, Judge.
Excuse me, Mr. Howard. This is Judge Keenan. What jumps off the page at me is a giant hole in the district court's analysis. There is no discussion about the fact that these are children. And I haven't really heard you say a lot about the fact that these are children. You seem to be, if you'll forgive my saying so, jumping back and forth between professional judgment and deliberate indifference, but you haven't really, in my view, framed the discussion of the fact we're talking about children. And the fact that children, under the law, unless they're certified as adults, are not criminals. Their conduct is not criminal conduct unless they are certified as adults. And it seems to me that this has to make a difference in the analysis, but yet I haven't heard you say anything. The district court was silent on this. And what's your response?
Judge Keenan, I absolutely agree with you that it is a critical element of the analysis here. Not only is this a non-punitive setting, but these are children, and even juvenile facilities that aren't under a contract type situation with ORR, as a general matter, are obligated to provide a environment that is care oriented for children. We have addressed that significance quite at some length in our brief, and I apologize for not having that be a part of my presentation thus far. But unquestionably, one element of why we believe that professional judgment is the standard, not deliberate indifference, is that in addition to being in addition to the statutory scheme in the contract, the fact is that the appellants that we're talking about are a class of children. Shenandoah itself, even apart from the statutory scheme in the contract, describes its mission as, quote, to provide an environment with an emphasis on continuing and expanding youth's education and providing proper physical and mental health services and support. I think that's a clear indication of its own recognition that it's dealing with children, not adults, and certainly not
juveniles
in setting.
Custody. Are juveniles in state custody provided the kind of mental health services that you wish?
Your Honor, we contend that juveniles, irrespective of the circumstances, are entitled to trauma-informed care.
I'm asking you, they're pretrial detainees and they're also juveniles in state custody.
Yes,
and I'm wondering if those, as a routine matter, are given the kind of mental health treatment that you would prefer.
They are, Your Honor, and we have cited a number of cases in our brief that both support the proposition that, not unanimously, but certainly the predominant number of cases that address the question of juveniles in the manner that you're describing, that determinations with regard to the adequacy of care in those contexts are governed by professional judgment, not deliberate indifference.
Well, I grant you that there's an obligation of humane treatment to anyone who's in custody of any kind. My question is, when you go beyond food, clothing, medical and dental care, and educational facilities, access to religious services, I don't understand why, when coupled with the things that you and I have just been over, why that isn't a perfectly sufficient treatment here. I mean, the DiPaola case, this is so very different from DiPaola, where they did absolutely nothing and they warehoused somebody without having a clinician or a mental health professional ever seeing them. But this strikes me as very different, and I think you're asking for something more than juveniles in state custody receive.
Your Honor, this would be a different case if not for the very clear statements of doubt on the part of Shenandoah's own clinicians with respect to the adequacy of the care that they're providing. If this case was like the Davis case relied upon by the appellee, in which there was no question that the care that the claimant received was adequate to the full extent that it was provided.
You know, all I can
but he was asking for more.
Excuse me, counsel, please. I have been in a lot of cases, school cases, in the Department of Justice and elsewhere, and it was almost inevitable in those cases that that teachers or educators or officials or whatever, they would always or routinely testify, the education we're providing is not adequate, the care we're giving is not adequate. And why do they testify in that way? Well, part of it is because they want more funding. And the quickest way to get more funding, as a general matter, is to say that what we're doing is not adequate. We need more. We need more. And there've been very few institutional cases where I haven't seen staff members and others saying we want more, we want more, we want additional funding in order to bring this up to the level of adequacy. I mean, that's just part of the dynamic of this, and I don't understand why you are attaching such dispositive weight to it.
Your Honor, I believe it deserves dispositive weight with respect to the grant of summary judgment, because the district court concluded that the basic facts recited by Shenandoah, i.e., that they provide a clinical appointment with the child every week, that they provide some kind of group therapy, and that they see the psychiatrist when he periodically visits, is constitutionally adequate care. When the testimony of Shenandoah's own people is that the clinical evaluations that take place on a weekly basis don't involve very much time, when the testimony is there really is no group therapy, notwithstanding the fact that it's contractually required, and when the testimony is, even from the psychiatrist, that he doesn't provide any, quote, talk therapy, and that he believed that the clinicians were the ones.
Are you proceeding under a contractual claim or a constitutional claim?
I'm not suggesting that this is a breach of contract action, Your Honor. What I am saying is that the contract provides some framework within which to evaluate the adequacy of the care. And the fact that even with respect to the minimal obligations that they have under the contract, those aren't being fulfilled. Certainly, it seems to me, in the context...
Are you seeking a trial on this, or are you seeking a remand for the district court to take additional evidence? What are you seeking?
We don't believe that there needs to be additional evidence in order for the district court, if it had thoroughly and carefully reviewed the entire record, to conclude that there are genuine issues of material fact that are triable.
Okay, so you're not asking for an immediate trial. You're asking for the district court to review the record and to take such evidence the district court feels necessary. That would be in the district court's discretion, in your view. You're not asking for a trial.
Your Honor,
you're asking for the district court to review the whole record and to take additional evidence if necessary.
Your Honor, if the record is deemed by the district court on remand to sufficiently establish genuine issues of material fact that have to be resolved at trial, then of course we would be prepared to proceed to trial.
But we don't know that the district court would conclude that.
No, we don't. And we certainly have no objection if the district court on remand concludes that on the basis of this court's analysis in remanding, that it's appropriate to reopen the record and take additional evidence as to the adequacy of the care, then that's what we would be prepared to do as well. We, I believe, are keeping our own time, and I just want to make sure that I'm not, I believe I'm up against my 15 minutes on opening. If the court has additional questions, I'm happy to answer them. Otherwise, I'll reserve my 5 for rebuttal.
Thank you. Rachel, are you on the line?
Yes, sir.
Are we keeping our own time?
No, I'm keeping the time here. That's what that bell was.
The bell just went off?
A couple minutes ago.
I didn't hear it.
Let me play it so you know what.
No, yeah.
Did you hear that?
That went off?
Yes, sir.
A couple of minutes ago?
I heard it this time, but I did not hear it before.
Okay, I'll make sure to.
I didn't hear it the first time either.
Thank you. All right. Sorry, Mr. Bodkins, you may proceed.
Thank you and good morning. May it please the court. The district court correctly determined that allegations that mental health care is not sufficiently trauma-informed do not establish a claim under the United States Constitution. During his first 10 months of placement at the Appalachia facility, which I refer to as the center, the plaintiff, John Doe 4, was evaluated by a psychologist, met with a psychiatrist on a dozen occasions, and met with a licensed professional counselor on at least 60 occasions. The district court's ruling should be affirmed for 3 reasons. First, Doe 4 lacks standing to seek injunctive relief involving mental health treatment on behalf of a class of minors without their legal custodian being a party to the case. Secondly, the mental health services provided by the center exceed the deliberate indifference standard, which was correctly applied by the district court. And then third, even if the professional judgment standard applies, the mental health services exceed constitutional requirements. Starting with standing, Doe 4 has to show that his claim is likely to be redressed by a favorable decision in this case to have standing. The Office of Refugee Resettlement, which is referred to as ORR, was Doe 4's legal custodian during the time he was at the center, and they are the legal custodian for all members of the certified class. Additional medical and mental health services are subject to approval by ORR as the legal custodian. ORR is not bound by any ruling in this case requiring additional mental health services because they're not a party. ORR could simply decline to provide the relief, or they could transfer class members to another facility that would not be subject to a court order to provide additional treatment. The center could not provide additional treatment ordered by the court or even agreed to by the parties in the absence of ORR approval.
Why not? Excuse me, Mr. Bodkins. The problem I'm having with your standing argument is, why can't the center provide a greater level of treatment? Why would they have to get approval for a greater level of treatment rather than a lesser level of treatment?
Despite the placement of a minor at the center, ORR retains the status as a legal custodian of all the minors, including Doe 4 and the class members. The treatment that's authorized under the cooperative agreement is routine medical and dental treatment, along with appropriate mental health interventions when necessary. The testimony in the record establishes that unless there's an emergency, that the center has to seek ORR approval to get any additional treatment, including any additional mental health treatment.
Okay, and I think that argument might be persuasive as to why this court shouldn't adopt a trauma-informed approach, because that's a policy decision, arguably, and a decision that needs to be made between the legal custodian and the care facility. But with regard to the adoption of a professional judgment standard for a child detainee, why is that something that this court cannot address? Because Shenandoah Valley is the care provider under the contract with ORR. And there has to be a measurement of the adequacy of their conduct. And measuring them against adult criminals and other adult detainees seems to me to be a really problematic square peg in a round hole. Why are you arguing against the professional judgment standard? What's wrong with that in the case of a child?
Well, cases where a professional judgment standard had been applied to a minor have been based upon a finding of a treatment or rehabilitation objective. The deliberate indifference standard it's not something that's been solely applied to convicted prisoners who are subject to different standards.
Also to certain other detainees waiting for trial. I understand that, but with regard to children, what is your objection to the use of a professional judgment standard when the children are not in an ability or do not have an ability to defend themselves the way an adult might? And why isn't this more analogous to the involuntarily committed mental patient in Patton?
If you look at the Patton case and the factors that are outlined there, the dispositive question I would submit is, what's the overall purpose of the facility? Doe 4 in this case was not transferred to the center to receive additional or more intensive mental health treatment. He was transferred there due to safety concerns. He had 9 behavioral incidents, and 6 of which were physical altercations and had been deemed to be a flight risk. So he was transferred to the facility due to safety purposes rather than treatment. And under the Patton analysis, that's really dispositive to a certain degree as to which standard applies. The Patton analysis...
There are 4 Patton, but there are 4 Patton standards. Why is that one dispositive?
Well, that one really gets to the overall purpose of the facility, and that relates to the first factor, and then also the second, which is the nature of the confining facility. The center is not a psychiatric hospital or residential treatment facility. It's a detention center. So it's not...
Right, but they shouldn't be accepting people. They shouldn't be accepting children unless they can provide them adequate medical care, including mental health care. I just don't understand why there is such a resistance to applying a professional judgment standard. The professional judgment standard is still very hard to meet. There has to be a substantial departure from accepted professional judgment. I mean, that's pretty hard to prove. And I just don't understand why there's such a resistance and a desire to pigeonhole these children into a standard that is most often used for criminals.
We agree that even if the professional judgment standard is applied, the district court's ruling was correct. The inquiry by a court, even under the professional judgment standard, it's fairly limited.
One thing I wanted to bring up with you is that my good colleague refers to them as children, and sometimes when I think of children, I think of people before the age of 10, and I think of them very sympathetically. This is a different kind of situation. It seems to me we're talking about a minor who may be 16 years old and is in the facility to control violent behavior. There's just a long history of violent altercations, and he's in that facility because less restrictive facilities simply would not accept him. And so you do clearly have something where it's not a mental health center. What you're trying to do is bring about some sort of behavioral modification, and they seem to have succeeded in that area. I agree with Judge Keenan that the professional judgment standard under Youngberg is a very difficult one to meet, and that's why it seems to me that what is provided here would suffice under either standard, and I'm not sure that we have to decide at this point whether there's a deliberate indifference standard or whether Youngberg applies. I don't understand that it makes that difference. But what else were they supposed to do? They prescribed all kinds of medications. He was regularly seen by clinicians. They succeeded in keeping him from self-harm. They succeeded in having his anger management improved by his own admission. He had made progress at this facility. By his own admission, he said, I was able to meet with either Dr. Kane or the clinicians whenever I wanted. But of course, it's never enough. But the center had succeeded by his own admission in several ways, procedurally, in providing him unfettered access to the three people, Dr. Kane and the two clinicians, unfettered access to those three people. And not only was there unfettered access, but there was a success achieved in the particular mission and purpose of the institution. They were left with an individual whom no other facility would accept. And they produced results. Thankfully and happily, they didn't make an ideal situation of it, but they made what was clearly progress. And they succeeded where other institutions did not. And to take an institution that it was designed to try to control anger management situations and did in fact do that, and which did in fact provide not the highest level of ideal mental health care, but as Judge Keenan points out, the Youngberg standard is actually very deferential, and I don't understand why it wouldn't apply here. I mean, it just this institution deserved one heck of a lot more credit, and it's being given for what it did and for what it accomplished. And you continue with sir.
Yes, thank you, Judge. Yes, that gets to our position in that the reason the Doe 4 was transferred from a less secure facility to the center was to address safety concerns. And then secondly, even if the professional judgment...
Mr. Bakken, what does that have to do with his needs for mental health? Because you're almost bringing up sort of a culpability defense oh yeah, well he was there because he was a problem. He was there because of security. Yes, we know that. But the point is, let me ask you this, the point. Do you agree that it is undisputed that these children suffer from trauma, severe trauma, mental trauma? Do you concede that?
Your Honor, there is evidence in the record that many of the children that are in the center's care have experienced trauma. Yes, sir.
Okay. Well, then, if you're going to do something about that from a medical standpoint, don't you think you have to address the trauma?
Well, that's not, let me answer both parts of that question. I mentioned the reason for Doe 4's transfer not as a means of tarnishing him or establishing culpability. I do so only for the purpose of the patent factors, which look at the reason for the confinement of the claimant and the nature of the facility. And
all right.
That fact.
Point taken. Now, address the second part.
Okay. The contention that trauma is not treated at the center, that is based upon testimony that was given by a mental health clinician in this case in the context of one minor who was not Doe 4, who had just returned from a weeks-long hospitalization for psychiatric issues. The clinician testified that she chose not to dig up and treat the trauma in the context of her first clinical interaction with that individual. The record, and even Doe 4's expert, Dr. Lewis, shows that the center has trauma-informed principles in the approach that it takes. Dr. Lewis,
and the record shows that the recommendations made by that sort of trial group, a lot of them were not implemented. Correct? Is that in the record?
Yes, the psychologist that evaluated Doe 4 after he arrived at the center gave a recommendation that he be transferred to a residential treatment facility. The center attempted to transfer him to several different facilities on a couple of different occasions. There were two impediments to that. The first is that since they're not the legal custodian, the center couldn't authorize it without ORR approval. And secondly, and more importantly, there was no facility of that type that was willing to accept Doe 4 due to the risk that his behavior posed in a less secure setting.
Yeah, but you're not addressing in terms of, but are you suggesting that he's the only child there that has trauma, past trauma problem? The countries they've come from, the journey they made to get here, you suggesting that's isolated to just Doe 4?
No, I'm not suggesting that. What I would point to is the basis of the district court's ruling was that Doe 4 failed to establish an individual claim for insufficient mental health treatment. So I think in the scope of review on appeal, that's the ruling that's being reviewed. I think it's fairly settled law that Doe 4 has to establish an individual claim before he can look to facts and allegations concerning other members of the class when bringing a Monell claim.
But Mr. Botkins, doesn't the district court have to address the fact that we're dealing with a child because that is a legal disability, similar to that of a committee or someone else who is in a protected status? So how can we accept the deliberate indifference analysis that doesn't even acknowledge we're dealing with a child? And they aren't all 16-year-olds. They can be as young as, 10, 11 in most facilities. I mean, it just seems to me that you'd be doing more good for the system if we just let the district court analyze this under professional judgment in the context of a child. It's still going to be a difficult standard to me, but it'll be a protection in place for a person under a legal disability, which a child is.
Even if the district court were to apply the professional judgment standard, it is their position that wouldn't change the outcome in this case. Professional judgment
right,
standard...
Right, and I understand that. Yeah, and if Doe's got a weak case, then the district court can say, okay, I'm applying the Youngberg standard. It's not a forgiving standard. you know, there has to be a substantial departure from professional judgment, and I just don't see that there. And then the case can be dismissed, but the district court would have considered it under a different standard and in the context of this being a child. What's wrong with that?
Well, if the district court is going to reach the same opinion, and that opinion is supported by a level of fact that's relatively undisputed in the record, then it seems to me there wouldn't be a point to address the standard if it's not going to change the outcome.
Well, aren't you forgetting the evidence that he didn't permit on professional judgment, part of Dr. Lewis, Dr. Wiseman? You can't just stop the clock right now. Go ahead. But there was several evidence that was based upon professional judgment that the court would not allow. It didn't consider.
Well, the court excluded Dr. Lewis's testimony, you know, on two grounds. The most important of those grounds was the fact that he was giving opinions based on a higher standard and higher level of care than the Constitution required, as the district court saw it.
Well, who knows what the Constitution requires? You keep saying that the Constitution requires, like, lays out some physician death manual. It doesn't. It talks about what is inadequate in terms of addressing present and demonstrable needs. If it's inadequate, that is unconstitutional in terms of deliberate indifference to a standard that's known. He didn't allow the doctor to talk about what the standards were. How are you going to know whether or not you're indifferent to a standard, professional standard, when you don't allow the evidence as to what the standard is? So you can't just go back and say, listen, well, we don't need to go back because this was enough to address that. We don't know because the evidence was cut off.
Well, Dr. Lewis's opinions included testimony that the center assesses for trauma at intake, diagnoses trauma, provides training in trauma-informed care. He also testified that the mental health clinicians made efforts to respond to DO4 but didn't go far enough. So his testimony shows that this is a dispute over the extent to which these services were based on a trauma-informed approach, and as opposed to a disagreement that should be constitutionally actionable under either of the standards. Thank you.
All right, Mr. Howard.
Yes, thank you, Chief Judge Gregory. Just briefly, the fact that DO4 was transferred to Shenandoah as a result of some pretty significant behavioral problems kind of assumes the conclusion in that his behavioral problems are attributable to the fact that he suffered trauma. I mean, it's certainly not usual for a 16-year-old or 17 when he got there to be diagnosed with post-traumatic stress syndrome. And there's a reason why, under those circumstances, where the facility knows that it's receiving children that have undergone trauma, and its clinicians concede that behavioral issues are attributable to the fact that they've undergone trauma, for the facility to determine, well, we're not going to address trauma, we're not going to treat it, we're going to basically ignore it and just pretend that all we have to do is tell these kids how to behave and hope for the best. That is essentially what this record reflects. And therefore, respectfully disagree with Judge Wilkinson, because part of the testimony that the district court strangely concluded could be excluded from Dr. Lewis was that not only was the treatment that DO4 received inadequate to his needs, but in fact, the overall course of conduct of the facility towards DO4 re-traumatized or aggravated his trauma rather than helped it.
What evidence is there of that?
There are Dr. Lewis's opinions, which the district court declined to consider because she said she was granting summary judgment. In the absence of a ruling that...
was there any prohibition when Doe 4 met with Dr. Kane or with the two professional counselors, the mental health clinicians? Was there any limit placed on what could be discussed? Could the post-traumatic stress syndrome be discussed with the clinicians? Could it be discussed with Dr. Kane?
It could have been, Your Honor, but the fact is that the clinicians say that they are really not qualified to treat post-traumatic stress syndrome, and Dr. Kane testified that he only really talks with the kids about their medications and the impact that the medications are having on them. And the clinicians also said that it was their understanding that Dr. Kane does not provide therapeutic treatment. He only handles medication administration. So
one thing that concerns me is you try to draw the strict line between behavioral improvement on the one hand and treatment of the underlying trauma on the other. But they are not totally separate and independent matters, because professionally, and you know, as someone with a good background in this field, you know this to be correct, is that one of the ways in which you treat post-traumatic trauma is with medication, which he was given, but also through behavior modification, that by encouraging someone in more constructive modes of behavior, you are in fact dealing with underlying trauma issues. If you can reduce the number of violent outbursts, which they did, you're in fact treating the trauma. We've been having this whole discussion as though the behavioral modification and trauma treatment were as different as night and day, and they're not at all. They're related, and I think a great many distinguished mental health professionals would indicate that one of the chief ways you can help someone overcome any kind of trauma or stress is by channeling behavior in a constructive fashion. Sometimes the way you behave on the outside affects your self-respect and self-regard internally. You can't just build a wall between external conduct and internal self-esteem, because when your anger management improves and your behavioral and your conduct improves, then people start responding to you in a more open and welcoming and positive way. And you must know this, because you have a good background in this area, that when you have behavioral modification, it just affects your whole surroundings and the way that you interact with everyone with whom you come into daily contact. And when you interact positively with people, you are addressing post-traumatic stress.
Your Honor, respectfully, I would say that what you just said, which I don't necessarily disagree with in the abstract, really goes to the question of the adequacy of the mental health care that Doe 4 received. And there are facts in dispute with regard to that adequacy, which compel the court to reverse the summary judgment and remand this matter for further proceedings. Thank you.
Thank you, Mr. Howard, and thank you, Mr. Botkins, for your argument. We can't reach you in our normal fashion of shaking your hands, but know that nonetheless, we are very appreciative and we respect your good arguments, and thank you so much. And we wish you safety and wellness. Thank you so much.
Wish you the same, Your Honor. Thank you very much.
Thank you.
Thank you. All right.
The court will take a brief break before hearing the next case.
Can we
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
All right. Ms. Keaton, you may proceed.
Good morning. May it please the Court. I am Lori Keaton, and I represent the City of Charlotte. We are here today on our appeal. Specifically, we have appealed the District Court's award of approximately $1.6 million to the plaintiff. And just to take a step back, in this case, the plaintiff has claimed race and sex discrimination by the Charlotte-Mecklenburg Police Department. He was a patrol officer with CMPD from March of '98 to August of 2013. And in this case, the defendant's motion for summary judgment was denied, as was our motion for directed verdict and for judgment on the pleadings. The jury ultimately awarded the plaintiff $125,000, finding sex discrimination but not race discrimination, and the court awarded approximately $1.6 million in front and back pay, and then $330,000 in attorney's fees and $22,000 in costs. We have filed our appeal in this matter and are here today because we believe that we are entitled to have our motion for judgment as a matter of law or for a new trial granted on numerous grounds. I'd briefly like to go through some pertinent facts before I get into the reasons why we believe we are entitled to have those motions granted. As you know, and I said, this is the Title VII action where the plaintiff was an African-American male police officer. CMPD is the law enforcement agency for the City of Charlotte and has numerous directives that the officers are expected to follow. The one that is most important for our purposes today is CMPD Directive 100-004. That is the directive that sets out the discipline philosophy for our police department. It sets out the factors to be considered in the application of our discipline. Those factors include employee motivation, the degree of harm caused by an officer's conduct, the employee's past record, and whether the errors they make are intentional or unintentional. The directive is explicit that past record is taken into consideration to determine whether consequences are going, whether the failure to meet department expectations will be considered. If you continue to make errors, you can expect the consequences of your behavior to become progressively more punitive. In CMPD, we have three main disciplinary bodies, one of which is independent of CMPD. We have internal affairs, which plays a large role in this case. It's important to know that internal affairs is independent. The sergeants work exclusively for IA, and they conduct our investigations. They do not select the cases to which they are assigned. They play no role in determining discipline. They receive our complaints, and they determine what roles of conduct are implicated, and they initiate charges and conduct investigations. They then produce a memo that summarizes the allegations, the rules implicated, and their factual findings. From there, it goes to the chain of command review board, and IA's role is over. IA sergeants do not supervise anyone. The chain of command review board is made up of a sergeant, a lieutenant, a captain, and a major, and then a civilian representative. They take the findings of IA, and then they make the decisions about discipline. The major is the ultimate decision maker. Finally, we have civil service boards, which are appointed by city council and the mayor. They make de novo reviews of any type of termination recommendation. With regards to Michael Tinsley, the plaintiff in this case, when he came to us in 1998, within a short time of his hiring, he began having performance issue, which I have laid out in detail in my brief. As I think you can see, I will not spend time going through the details, but he had approximately 13 write-ups for tardiness, failure to report issues, 7 write-ups for investigatory issues, 3 for honesty, and 1 for insubordination, which was ultimately overruled by the chief. Amy Aquino.
This was what, you said, in the last century?
That would be from 19... I'm sorry, Your Honor.
I can't... When?
Oh, I'm sorry. That would be his record from March of 1998 until April of 2013.
Okay, when was the last time he was tardy?
Well, the last time he was tardy would have been, that would have been in 2000. I can give you the exact date. I'm sorry. I think that was in 2011 was the last time that he was tardy. Let me give you the exact date. But as set forth, and I'll look for that. And as I'm, hang on 1 minute.
When was he fired?
He was fired in 2013, and I'm sorry, I'll tell you the exact date of the last time he was tardy. But as I'm looking for that, the one thing I'll mention is the last time that he had an issue with tardiness, I'm sorry, was 2012. But one thing I'd like to point out, Your Honor, is that going back to our discipline philosophy, the point of looking at these in this manner is to point out that, as you will recall, as I mentioned, it is progressive. And so the fact that we're seeing these repeated 13 write-ups for tardiness and failure to report, 7 for investigatory issues, would be very troubling under our discipline philosophy, if that makes sense.
Well, I'm not sure it makes sense or not, but how many accommodations did he get since he's been officer?
He does have favorable reviews, as Ms. Sumter pointed out in her brief. He had gotten good reviews in general. He had received favorable comments about particularly his patrolling of the skateboard area, the skateboarders in Uptown. So he did have some positives amongst this, but he had continual issues with discipline, and he also had other times that were not reflected in these where he was given, oftentimes he'd be talked to and it would not be reflected as the trial transcript reflects. And so,
okay, but the jury heard. Wait a minute. The jury heard all of this, right?
The jury did hear this, Your Honor. I agree with you on that point.
But the jury must have concluded that that wasn't the reason that you fired.
Well, I think that unfortunately,
unfortunately, what? Did the jury hear all of this?
The jury did, but the piece of the puzzle that we're here to talk about.
We're here to talk about what I'm asking you about. What I'm talking about is that the jury heard all of what you're talking about. The question is whether or not, in fact, that really was the reason. Because you're going back, I had to pry out of you his good things he did. And you going back to what, 1989? You said he was tardy, and then you said the last one was 12, right? And then
1998, but the most recent ones, as you know, or as you've seen, were actually going right up until the date of his termination. His last hearing was for things he had done in April of 2013, in the weeks leading up to his termination. So his behavior stemmed.
Counsel, are you going to let me finish?
Yes, Your Honor, I'm sorry.
Okay. Well, what was his last evaluation?
He received a good evaluation.
Well, then all of those, when they evaluated, did they know what his record was back to 1989?
I think that his supervisor, yes.
Well, didn't they? Well, they would have that, but yet they said present time, the last evaluation, he was performing well, and he was in good standing. It was all because of this incident with Aquino. Right, and the jury must have determined that was the real reason he was fired, right?
No, Your Honor.
And the question is, what is not? You don't think they concluded that?
No, respectively, Your Honor. Respectfully, no, Your Honor, because the person who sat on the board, she gave testimony at trial.
The board. I'm talking about the jury. The jury. We're not talking about the board. This is the jury trial.
Well, I think that the jury only heard about, I think the issue the jury and what we're here about today is about the comparator issue. And so I think the jury found there was discrimination here, but they were not given a comparator to compare him to. And so I think that's the issue we're here about today, Your Honor, is I think the issue is that Amy Aquino.
That's what, wait a minute. But counsel, you're saying that's the issue, but the jury, they're the ones who look at the whole picture and try to find the truth. They're the finders of fact. Now, you're saying that factored into it, but they must have believed that really wasn't the real reason, that the comparison was there's the same activity involved. They had an affair, right?
They did have a relationship.
Right?
They did. Correct.
Right. And did she accuse him of a crime?
She did accuse him of rape. That is correct.
And did you investigate that, whether or not that was true?
It was investigated.
Would you find it was true or not?
I think that what they ultimately found was all members found that it was true, except for the main chief found there was not enough evidence, so he was not disciplined for the rape.
And did the city pay money for slander?
The city paid after he was terminated. She sued him, and the city paid because the city had forced her to be interviewed under because she did not actually report the rape, someone else reported it, and she really did not want the rape reported, and so the city went ahead and paid for it because they had put her in the position to be interviewed and forced her to do that, and so the city made the determination that it was the right thing to do to pay for that, given they had put her in that position. That is correct.
Go ahead, Judge.
Chief, I don't mean to interrupt you. If you still have some further questions, I can wait.
No, I do have further questions, but you go ahead.
All right. I would like to ask you about the comparator issue, and I just want to make sure I understand your argument. Your argument is a focused one, that there's not a comparator, and I understand that what you're saying is that the records of the two individuals are simply not comparable, that Mr. Tinsley's performance record over the years was materially worse. But I thought that another argument that you were making with respect to whether there was a comparator or not had to do with the composition of the CCRB. And as I understand it, the personnel and membership of the CCRB rotated. And so what is your argument with respect to the rotation and how it bore on the comparator question, and whether they actually had apart from the investigation, whether they actually had a single decision maker? Could you address the rotation on the CCRB?
Sure. So the CCRB, they would have never had the same, the way that the CCRB works is that there's never going to be the same 5 people. It's virtually impossible for there to be the same 5 people on the chain of command review board, because the way they pick that, it's random, and they pick people just based on their calendars, but it would be virtually impossible to have the same person on the chain of command review board. And so they would never be having decisions made by the same chain of command review board, and so that's important. It's also important to note, and it's important to point out, that Ms. Aquino and Mr. Tinsley did not have the same supervisor. So that's another very important point to why they would not be proper comparators. And as this court is aware, under Haywood...
For all 5 members on the CCRB, were they 5 different members for both Aquino and Tinsley?
Yes, so there is no evidence to support that they ever had any of the same members in their chain of command review boards.
You think that weighs against the presence of a comparator, that plus the difference in recommendations?
I do think it weighs against it, as does the presence of the Civil Service Board. I believe that the
the lack of a single decision maker in that sense, although there was the investigator was the same. One other question I had here was I noticed that Mr. Tinsley ranked first of 118. I don't know whether this is correct. Ranked first in 118 officers for arrests and traffic stops and the rest. And what I want to know is, what is your opinion of which way that cuts? If it's true, if it's correct, it could lead to the conclusion that this is somebody who's doing a fine job, but it could equally lead to the conclusion that that he belongs in that 20% cohort of police officers that are overzealous and bad apples and too quick to use or misuse their authority. So what significance do you attach, if any, because that could make a difference in whether there's a similarity and a comparator. What is your thought about the significance that would attach to that?
I think that it illustrates that Mr. Tinsley was, would the court like me to finish my answer?
Yes, sure.
Okay. I think that Your Honor hits on a good point. I think that what it supports is the fact that Officer Tinsley, was good at the things that he wanted to be good at or focused on, but I think that what his entire history from 1998 to 2013 reflects is that he struggled very much with anything that was not something he wanted to be focused on. So that was kind of the one area, and there's testimony from numerous supervisors about this point. He enjoyed that area. It was something he liked to do. It was something he enjoyed. But when there were other things he was asked to do or told to do, he would not perform well, and he would tend to have, issues. And so I think it does show you that he could do well when he wanted to, but I think the other areas illustrate that he struggled in numerous other areas and was singularly focused on that area.
Ms. Keaton,
were all the arrests justified, or were some of them thrown out in court? What?
There is no evidence of which I'm aware that any of the arrests he made were problematic or thrown out in court.
Ms. Keaton,
I wonder if you might...
Judge Keenan, I think, has a question. Go ahead, Judge Keenan.
I'm sorry.
Yeah.
Yes, Your Honor.
Thank you. And Judge Wilkinson, were you done? Or?
No, I'm fine. Before it's all through, I want to hear about the front pay award in particular.
Okay. If I could just slip in here with one question.
Sure.
You thinking, Ms. Keaton and Ms. Sumter as well. What I'm concerned about in this case is you have the investigatory and disciplinary structure of the police department is such that it really doesn't fit into our Title VII jurisprudence. And so what do we do with a case like this when I think you have to say pretty clearly under our case law there isn't a common supervisor? But surely there must be a remedy under Title VII for somebody who has been the victim of discrimination. So where do we go from here on that?
Your Honor, I think
can a police officer never be subject to Title VII? Can a police department never be subject to Title VII liability or any other employer if they structure their disciplinary process and structure their review and decision process for retention in a way that there never is a common supervisor or a common decision maker, and thereby attempt to avoid Title VII liability? How do we deal with this problem?
And I certainly understand, and I appreciate exactly your concern and your point. I think in this case, however, we see that this isn't a situation where there could never be a Title VII claim. It's just, in this particular case, we just happen to have two people who are so dissimilar, Ms. Aquino and Mr. Tinsley. You know, the Charlotte-Mecklenburg Police Department has 13 divisions. So we're talking about two officers in different divisions. No, you know, they do not have the same supervisor. They do not have the same disciplinary type history. So I don't think it's a situation where, and I do agree with you that there are some, you know, we've seen cases where there are situations where you have, where you would never have a Title VII claim because the way the company is set up. I do not believe that the Charlotte-Mecklenburg Police Department is that type of entity, but I do just believe this is a particular case where there's such dissimilarity between the two parties that, you know, you would not have, that they don't represent the proper parties to be comparators, because the very reason. Oh, I'm sorry.
Yeah, Ms. Keaton, and I didn't mean to cut across you there. So what I'm hearing you say is that before getting to the troubling issue of could anybody bring a Title VII claim against the Charlotte-Mecklenburg Police Department, I'm hearing you say that the records of the individuals involved show they're not comparators. Is that what you're saying today?
That is what I'm saying today. I'm saying that I think that
yeah, I'm sorry, because I understand that point, and we've got to deal with it in our decision. But I don't think you've really given me an answer as to the second part. And I agree with you that Mr. Tinsley has a much longer disciplinary history than Ms. Aquino. But if we disagree with you on that point in terms of whether they're comparable, let's just say we do. I'm not saying I would, but let's just say we do. Then we're faced head on with the problem of no common supervisor, no common decision maker, and the situation we're under, how the city of Charlotte sets up its police department, it doesn't look like there ever will be. So how do we deal with that? Because I just want to make sure we aren't doing something in this case to put a stamp of approval on a system that would never let anybody recover.
Sure. And I think the cases in our circuit, in the Fourth Circuit, have talked about the need for flexibility, which I appreciate and understand for the very reason of what you're talking about, which is we cannot have a hard line where we say you've got to have the same supervisor, you've got to have, you know, we can't have these rigid rules. And I think that those cases represent the very cases we need to have, and I would assume this case would fall under that same gamut where you all are going to have to look at the facts here, and you would not produce an opinion that says there's a black line, you know, a hard line where it has to be these factors, but every case you have to weigh the variables, because we cannot have a line that says you have to have the same supervisor, you have to have the same this, the same that, because I do understand, and I think the prior cases and some of the cases that Ms. Sumter cites in her brief talk about this very fact that you've got to have flexibility in this analysis. And so I would think that that is how we would handle this, is that we would say we're not going to have this be an inflexible requirement, because if we do, we could create situations where we allow companies and entities to avoid Title VII, and that would not be the result that we would want to have. And so whereas I think the structure as it's set up now, because you do have supervisors, you know, I think now you already have a structure at CMPD where we could be liable for Title VII as it currently exists. I understand the concern as a general proposition that you could have companies and entities that could avoid it.
Okay,
but there's no indication here that that Charlotte had set up this particular structure to avoid Title VII liability. There are reasons for this type of structure, and I think Judge Keenan's point is excellent, and I don't think you can attach dispositive weight to it. It seems to me that it's one of a number of factors. One thing, this kind of structure does have a certain have a certain number of advantages, because if you have the same people on the CCRB day in and day out, they become the most unpopular members of the force, or they become the most feared members of the force. And if it's always the same disciplinary panel, sometimes they exercise authority internally to a degree that they shouldn't. And also because these disciplinary matters are very disagreeable within any institution, whether it be an educational institution or an elective body or police force or anything. I mean, nobody really welcomes the idea of entertaining disciplinary complaints and making these disciplinary judgments over either of fellow members of the force. And so what a lot of institutions do is they spread it around, and they find that it's more equitable that way, because they don't saddle one group of people with a permanent disagreeable role. So it has its purpose, and it's a very legitimate one. And I guess, but Judge Keenan's point is certainly a good one too. You don't want it to become a mechanism of avoidance. And I see that the only way out of this is to find out whether it's set up for legitimate reasons, and also to simply emphasize the point that it is one of a number of factors, and that it just can't be a dispositive one, and it certainly can't be a carte blanche to avoid Title VII liability, because that's not the kind of thing that anyone would want. It's a multi-factored analysis, and it's important, I think, that it be viewed in that perspective, that it may be relevant, or it is relevant, but not dispositive. There's an awful lot of room for evidence that is relevant but not dispositive, and maybe that's the situation here for an instrument of institutional governance that can make a certain amount of sense.
Yes.
Counsel, Ms. Keaton.
Yes, Your Honor.
When I asked the question, I didn't suggest when I said they had an affair, I don't mean there was anything scandalous about it. They were consenting adults, and neither one was married. I'm not talking about that. But was it against department policy for them to have a consensual relationship?
It was not.
Okay, it was not. Okay. Now, so we're talking about a comparator. Judge Keaton makes a great point. But in this case here, if in fact that the reason that was related to, the jury believed that the real reason that he was fired is based upon the relationship, and not those things you talked about going back to being late or things like that, or what Judge Wilkerson was talking about, taking a commendable thing. And I appreciate that you didn't suggest that having a good record in arrest might mean that they're being overzealous. There was nothing to indicate that or any of his arrest overturned. So thank you very much for that candidness there, because that's unbelievable that a great record hurts you. Anyway, but the commonality in this case is really IA, the investigation. If the jury believed that he really was, I know you're not going to agree with this, but let's say, I'm going to say hypothetically, I don't think it's, but I got a jury verdict on my side, let's say if the jury really believed that the reason it was fired was because of the relationship, and both of them were in a relationship, and she was not fired and he was, would you agree that she would be a comparator?
I don't believe that she would be a comparator because I don't believe that, I still believe you've got the same problem. I don't believe just being in this relationship would be sufficient to make the two comparators, respectfully.
Well, why not? Because the investigator, although you have this board, it was the findings of the investigator as to whether or not it seemed like there were inconsistent answers given in an investigation that ties them in here. Unlike most cases where you don't have the same supervisor who would examine the same performance, understandably normally compared. But here, if the jury believed that the real sine qua non of this case was the affair, and that's what led to the termination, then, and you had the same investigator. As a matter of fact, you put one of the investigators' interviews with her in this case. I think it was 51 Aquino from 5/17, 2013 interview, which is interesting. You put that in the record. But if they believe that was the real reason, because in Title VII, for example, most people don't go around saying, I have animals because you're black. I have animals because you're a woman, or because you're whatever. It's normally circumstance. And if the jury believed that he really was fired for that reason, why would she not be a comparator? Because they both were investigated. Go ahead.
Well, they both were investigated, but the difference is, so he had the additional thing happen with the church parking lot, but then I think we have to remember that ultimately, he goes before the chain of command hearing. They specifically say, and then you have the Civil Service Board hearing to terminate him, which is an independent body. And so I guess I'm just looking at this differently. I don't believe that's the reason. That's just my opinion, but I don't think that was the reason he was terminated. So are you asking me if that's what the jury believed, or are you asking me if that's what the record?
No. The record, it's enough in this record to believe that that's why he was fired. And the jury found it was the judge who was there presiding, who heard the witnesses. It's amazing how we can sometimes normally people shout, oh, it's a jury trial and we have to refer to converted and that. But now when the jury comes back now, there's reason that, there was nothing there. But there was enough evidence in this case that was the triggering and the main reason. And the jury believed that it was. And the jury was very exacting. They said, no, this had nothing to do with race. Threw it out. This wasn't some runaway jury. They were very exact. You can tell. No, there's no evidence that. But there is evidence that a woman was treated differently than you. She wasn't fired.
And I guess my issue is that I don't think the jury should have been given Amy Aquino as a proper comparator to start with. I mean, I think that's where the issue lies, Your Honor, is that she should not have been presented to them as a comparator because she wasn't, because she didn't meet the qualifications to be the comparator to start with. And so therefore, when she's put in that position to them as though, yes, this is who, the judge unilaterally decided in his summary judgment ruling, he unilaterally said this is going to be the comparator for the case. She's the one and only comparator based on Burke as the common supervisor. I don't think that was the proper decision. And so then I think everything flows from that. I don't think that Burke, as an IA sergeant who made no decisions and who had no ruling, no ability to make any decisions about Aquino or Tinsley. So I think the jury was given an improper impression, for lack of a better word. That wasn't what should have been given to this jury, and that's what resulted in what we have here today. So I guess that's what I'm trying to convey, Your Honor.
Well, I asked you.
Go ahead, Judge Wilkerson.
You go ahead, Chief. I'll hold my question until you're through.
So basically, you're saying the law is that you can totally inculcate yourself from any racial discrimination sex discrimination, again, like what Judge Keenan was relating to, because you said that there were tiers in terms of who did what, but the common denominator was the investigator. And no matter how much you put in terms of, for example, in this case, what difference does it make? See, for example, the one thing that was not related to this was parking lot, right? He was fired because he was parking in a church parking lot, something like that?
Well, I mean, the Civil Service Board said that they looked at his entire record all the way back to 98. But yes, in the last hearing he had, they said that the thing that was added was the 4 charges from the what they found on his phone after they looked at both he and Aquino's phones, and they both got disciplined from what they found on their phones, and then they added the April 3rd parking lot incident. So yes, I mean, they both received discipline.
And what did you add to her discipline?
Well, she received 40 hours without pay as a result of what they found on her phone, and then he received 4 charges for what they found on his phone, and then an outside party submitted a complaint about something that happened on the parking lot. So those were the things that were going into that final chain of command hearing, and then they said that ultimately Major Lester said they all unanimously agreed with the termination decision. And just one final point I'd like to add is it's important to realize that the Civil Service Board hearing where they voted to terminate him under that Stimson v. City of Tuscaloosa case, I would say that the role of the Civil Service Board, arguably that would break any causal link here between any sort of animus and the termination. And, because that is an independent board that is appointed by the mayor, and they conduct a de novo hearing, and they alone have the power to do the termination. So I would just like to mention that point as well to the panel.
And his record, has he ever been disciplined before in terms of getting suspended?
He had suspensions. I mean, their suspensions will be so many days and things like that. So he had prior times where he'd been suspended for a number of. They do it in hours, but then it translates into days. Okay,
so small. And you said progress. I mean, so was he ever put on any kind of performance review?
Not that I'm aware of, no. I don't think he'd ever had like a specific where he had been put on days. He had comments made to him about things that he needed to, and you'll note that in the brief I'd noted times where he had been told certain areas where he needed to work on and things like that. But he had never specifically been, he'd received 3-day suspensions, he'd received counseling on certain areas and things like that, and then comments had been made to him specifically about areas where they were concerned, and those are specifically noted in the record, in my brief rather. I'm sorry.
And then he was fired because of this.
He was fired because of the totality of the record consistent with the discipline philosophy of CMPD. So they looked at the entire record according to the trial testimony. They took into account everything as they are supposed to. So they had everything in front of them, not just this. They had everything. She said they looked at the entire...
What you're saying is that he could have been late one more day and been fired for that because you look at everything he's done before.
That would have been up to the civil service. That would have been up to the chain of command hearing, first of all. They would have had to look at it, and then it would have gone to the civil service board to make a decision. So the chain of command hearing, Major Lester said that they looked at the whole record over his whole career when they made their decision. And then the civil service board said they looked at the entire history and his entire record, and what they saw was a pattern of not following rules. That was the testimony from the civil service board.
Yeah, it's interesting. If this is the law, then it's amazing that nobody's ever a perfect comparator, is it? I mean, for example, you could say, well, you're not hiring, you fired 10 black people, and you haven't fired any white person. You say, well, none of them had the same thing. They were late on Monday, you were late on Friday, so you're not a comparator. Or they they had different reasons. I mean, you can play all kinds of games with Title VII. I think it's hard to say that Congress meant this. I don't know about now, but in 1964 and those things like that, and looking at the statutes and civil rights that is turned on their head now. In this instance here, we basically, the way you were set up, that he had no redress. That's the law. In these instances, if you had just flat out done it based on clear indications there was a difference, it wouldn't make a difference because they're shooting out a comparator. That can't be the law. Not in the facts of this case, but you're saying that's the law. You're saying that's the law. That's the result.
I'm saying that under the existing law, my understanding of the existing law, which certainly I've realized I defer to this panel, but I'm saying that based on the case laws that exist now, my understanding is it's important to have comparators for the reason that we need to establish an adequate comparator, and that would require that you have, it's important to have adequate comparators, and that requires you have to be similar in all relevant respects. And that means if you have different decision makers, different supervisors, you're seldom comparable to establish a prima facie case of discrimination. And so I'm not trying to suggest that the law is unduly harsh. I'm just looking at Haywood and that line of cases and trying to apply it here. And it would seem to me that under Mitchell v. Toledo Hospital, under all those cases, that what we have here is not a comparator. And so that is where I'm coming from. Haywood v. Locke, Mitchell, those cases, Your Honor. So I'm not trying to be unduly harsh. I just don't think this meets the standard for a comparator under the existing law.
Yeah, I think I'm finished with this. Go ahead, Jared. Go ahead.
I'm sorry. Ms. Keaton, thank you. This is Judge Keenan, and I want to ask you, to what extent are you relying on the findings of lack of candor against Officer Tinsley? I haven't heard you talk about that. Is that not a significant factor in your analysis? Yes, I mean, he was found to be lacking in candor, and she wasn't. Is that something that we need to think about or not?
I do think it's important, his lack of candor. He was found, as you noticed and noted in the record, that there was a problem about his lack of candor in the discussing the rape. Even though he was not disciplined for the rape itself, there was the testimony at trial where it was said that he told 3 different stories about what happened on the night of the rape. So I think it is something that is important, and that Chief Monroe later stated that that would be something that he would no longer be able to utilize Mr. Officer Tinsley in the same manner due to that finding. He would not be able to testify at trial, etc. And so I think that is an important piece of the puzzle here, that in addition to everything else in the record, Chief Monroe did make that comment that would have made him, he would not be able to utilize him in the same way due to the finding of the lack of transparency. And so, yes, I do think that is, thank you for bringing that up, that is an important piece of the puzzle as well in all of this. And again, I think it goes to the fact that it goes to the whole record. And just one little 2 seconds, I just want to add to that, that is brought up by Judge, that has been brought up before by Judge Mullen. And one thing he mentions is that Amy Aquino was not punished for her lack of candor, and this is an important point. There's been criticism of the fact that she was texting during the 2 to 3 a.m. window when she was allegedly raped, and he took that to mean that she could not have been raped in that window. But I will just point out that obviously she could be raped between 2 and 3 a.m. in spite of the fact that she was texting for some small period of time during that window. So it was an unusual thing to be put in a court order that someone could not, or their integrity was called into question because they claimed they were raped in a certain time period and they were texting during some small window. So I just wanted to mention that because that was brought up about Ms. Aquino's integrity. So, but yes, I do think the integrity issue is relevant to the overall picture about the termination.
Well, were they having a Were they having a consensual consensual relationship at the time? I'm not talking about
they had.
I'm not talking about the alleged.
They did.
I'm talking during that time. Were they?
So yes, so they had an on again, off again. I don't know the exact word. Relationship would be appropriate. They had a sexual relationship that was on and off, and at this particular occasion, it was a time when her testimony was that she refused it on this occasion.
Right.
And it was on and off again situation.
And because they believed that he wasn't telling the truth, then he was determined to be no longer a fit police officer because of that incident. That was a big part of it, wasn't it?
I think a part of it had to do with the fact that there were inconsistencies between, the different times he was interviewed. There were some differences in what he said about what occurred, and so that was concerning. And then so that there was concern about that.
Well, at the hearing, Tinsley testified, and this was for the first time, that Officer Aquino said stop.
Yeah.
And his view of the rape is just gone all over the place, because at first he says it was consensual, and then no, at the hearing he says no, she told me to stop. And
yeah.
And that's this is the difficulty that I'm having with the comparator, and it doesn't just focus on the lack of a single decision maker. That's a part of it, to be sure, but it can't be dispositive. But when you combine that with the difference in the records, the cumulative nature of the discipline, and when you combine it with the lack of candor and the wavering stories as to the rape, at a certain point in time, it begins to pile up, and it make you question: well, are these people really are they really similar? They seem to, because a lot of the issues that are noted with respect to Mr. Tinsley are not noted with respect to Aquino. I don't think either one of these individuals is without a blemish. They're not ideal officers in my view of the record. But for a variety of reasons, I have my doubts, some real doubts that they are comparable, and they're not. The doubts seem to be based on undisputed evidence. I guess that's the gist of what you're saying to us, isn't it?
Yes, Your Honor.
All right. Is there anything further?
Well, I know I'm way past my time, so I was just stopping. I don't know if you all want me to finish or what you want me to do.
All right. Well, I don't hear any more questions. All right. Ms. Sumter.
Good afternoon, Honors. I'm sorry.
Go ahead. No, go ahead.
I'm Geraldine Sumter. I represent Michael Tinsley, and I have listened to your questions attentively and would like to have an opportunity to respond to your questions as I make my argument. In this appeal, the defendant has the burden of showing that the judge denied their motion for judgment as a matter of law based on the fact that there was no comparable evidence. And on its motion for a new trial, this court reviews the district court denial of the motion for a new trial on a clear abuse of discretion. What we have in this case are two employees who alleged inappropriate behavior by a coworker. One was the female, Amy Aquino. The other was the male, my client. Their complaints were treated differently by IA and by the department. In order for you to understand why we say Amy Aquino is a comparator, I need to walk you through the facts related to the discipline philosophy. And I want to tell you that, as the court said in Bostwick versus Clayton County, it does not matter what a employer's name for its policies are. What matters is how it applies the policies. And so, as far as Mr. Tinsley is concerned, they can call their disciplinary policy anything they want. They can have whatever factors they want to be considered in the disciplinary policy, but where Title VII is implicated is in the administration of that policy, and that is the problem with this case. So all of your questions and concerns about whether a policy such as this automatically prevents Title VII application might be for another case, not this one. In this case, the evidence presented to the jury showed that there is no way that there would ever be a same supervisor in the cases and the violations which are brought before this court. The defendant's policy clearly says that in disciplining employees, there are certain violations for which supervisors are responsible and certain for which the Internal Affairs Department is responsible. The issues in this case are only handled by Internal Affairs. Now, under the defendant's policy, and its own witnesses testified to this, that once IA receives a complaint or information about a rule violation, it is IA which decides what, if any, charges would be brought against the employee. It then builds a case if they find that there is a fair probability of a violation. At all times relevant here, the Internal Affairs Internal Affairs Department consisted of Sergeant Burke, Captain Maglione, and Major Spelby, as it relates to the actions which occurred in 2013. And I will tell you that the record shows that before these incidents occurred in 2013, Mr. Tinsley was not in jeopardy of losing his job. The Internal Affairs officers spoke among themselves about cases. They reviewed each other's work, and the major had the responsibility of having discussions with then Chief Monroe about what was happening in the investigations. So this notion that the Internal Affairs investigation is independent is not true. And the record, the testimony in this case proved that it was not true, and the jury accepted that. In fact, when the IA completes its investigation and determines that a violation of certain rules have occurred, they don't make a decision about punishment, but they send those recommendations to the chain of command board. The Internal Affairs officers, all of them in the chain who have anything to do with that investigator, the sergeant, the captain, and the major, sit in on the command review board throughout throughout the entire process, including its deliberations. Now, the client is not allowed to sit in on the deliberations. The client is excused. In the present case, it would be IA which initiates the action, and for all intents and purposes is analogous to a supervisor taking action. But even if you did not decide that IA's actions constituted the initiation of the process, which I think would be very difficult to do given the record in this case, the evidence shows that Chief Monroe, in an unprecedented move, appeared before the Civil Service Board, which is that board of people appointed by the mayor and the county. And just for the record, in the city of Charlotte, police officers and fire department employees can only be hired and fired by the Civil Service Board. So the chief of police makes recommendations to the Civil Service Board. And on paper, the Civil Service Board appears to be independent. The undisputed evidence in this case is that it is not. The plaintiff called retired Major Norman Garnes to the stand. He testified that he sat on the Civil Service Board for a full term and had been 3-year term and had been scheduled to do another term. But he quit, he said, because I cannot stand the way that the police department was dealing with the different type cases. He specifically pointed out a case where he thought the Civil Service Board and the chief of police worked together. His example of that was that the city had a rule that if an officer failed, or rather tested positively for drugs, that he must be fired. That's a black and white rule. The board was prepared to discharge him, but the chief of police came over and prevailed upon the Civil Service Board to violate a common tenet and rule that says that a police officer who tests positive for drugs must be fired. He convinced...
Ms. Sumter, excuse me, Ms. Sumter, this is Judge Keenan. What does that have to do with this case?
What it has to do with this case is that the quote, independence of this Civil Service Board was brought into question by that testimony. And it was testimony upon which a jury could determine that that decision was not independent, that the decision to terminate...
Could I follow up my question if I could?
Yes.
And I apologize. I didn't mean to cut across you. It's so tough with the telephone, you know, or with any kind of video or telephone.
No problem, Your Honor. No problem.
But in any event, it seems to me that what we've really got to look at here is that we have on one side Mr. Tinsley, who had 29 disciplinary violations over a 20-plus year period, plus a finding of lack of candor in the rape investigation. We have Aquino, who only had a, 3-plus year history with 3 incidents of discipline and no finding of lack of candor in terms of the police department findings. So can we say that those are adequate comparators based on the factual record? That's really what I'm grappling with here, because I'm totally sympathetic to the fact that the police department is so structured to make it hard to make a case. But these facts seem to show a very dissimilar record between the two. So help me with that.
First of all, Your Honor, you are wrong in your count of disciplinary actions taken against Aquino. There are more, and they're set out in my brief on page 19. I think you are also incorrect in the number of disciplinary actions that you say are taken against Mr. Tinsley. The record will show what they are. But if your question is, because Aquino did not have a record in this police department similar to Mr. Tinsley's, then she must not be a comparator. That is not the beginning or the end.
She must not be. No, Ms. Sumter, we're not in an adversary relationship.
Yes, I'm not, I hope you are taking my response to be that, Your Honor.
Yeah, I'm trying to figure out how we decide this case fairly to both parties and how we would write an opinion in the case. And so that's why, and I'll go ahead and count, I've got my list here and perhaps the list is incorrect, but in terms of the actual numbers involved, but there is a very marked dissimilarity in the number of incidents of discipline. And so how do we deal with that in the analysis? That's all I'm asking.
All right, so this is how you deal with it in the analysis. I ask you to consider plaintiff's other evidence of behavior by Aquino, which was never investigated, which, if it had been, would greatly increase the number of disciplinary actions that she should have received. Now, what happened, first of all, is there was a relationship between them. She wanted more of the relationship than he did, and when he told her no, she engaged in a concerted stalking campaign against him. He reported that behavior repeatedly. Stalking of a citizen of another person, especially while she is on duty, and sometimes leaving her division, amounts to rule violations, including a criminal charge. IA was made aware of that, and Burke admitted in his trial testimony that Tinsley told him about this before any of her allegations of rape. And so what you have is Mr. Tinsley going to the department and telling them about things that Amy Aquino was doing to him, and they basically took an attitude that he was a man and therefore a woman couldn't be intimidating to him. She then skirts on the issue of whether she should have been disciplined for stalking. IA had the ability to initiate charges, and in fact, for the number of complaints that Mr. Tinsley made to Burke and to others, under their own policies, a charge should have been initiated. No such charge was done. Further, Aquino was cautioned by Mr. Tinsley's supervisor not to show up at Mr. Tinsley's workplace after he caught her there on 2 occasions. She continued. He then reported her to her supervisor. And as it turns out, the record shows that her supervisor, and this was in May of 2013, in January of 2013, her supervisor had gotten reports from some of Amy Aquino's co-workers that she was not appearing at calls because she was out of the division. Only in May, after Sergeant Metavolis makes a complaint, does she...
Right there, excuse me, counsel. Isn't it fair to say as well that there were complaints against Tinsley that were either never investigated, never charged, or whatever? I mean, they were... The rape was never criminally charged, but it was, pretty questionable behavior, to say the very least. And he's I'm just going on what's the record, because there could be all kinds of things as background as to when the two of them were in an affair and when they were not in an affair, and when the relationship was consensual and when it was coercive. But what we have to go on is not all of these accusations and counter-accusations surrounding their relationship, but what was actually reported and documented in the disciplinary records. And when you focus on that, which seems to be the most relevant thing, there is a disparity, and it's not just a small disparity. That's one of the difficulties that I'm having here, because there's a lot of background here, and there's a lot of, the way there always is, there's a great deal of acrimony when relationships are on and off again, and when there's when they break off, they're surrounded, I guess, by revenge in some ways, and they're always mutual recriminations about this and that. But if you focus on the record, there seems to be a real difference. That's the problem I'm having.
Okay, Your Honor. I think that you have to...
And I grant you the point that the record here for Officer Tinsley covers a longer period of time, and so I'm well aware of that. But the period of time that Aquino covered was not a short period of time, and even granting that there's a longer period of time for one, there's still the disparity still persists. And one of the things that is concerning about the disparity here is that many of the violations are repetitive. And your opposing counsel said, well, he was good at what he wanted to be good at, and he was indifferent or not as good at what he didn't want to be as good at. And but the problem is that the infractions tend to indicate that he may not have been concerned with making his behavior more constructive, as when he cited for failure to show up for duty, failure to show up 8 different times, failing to notify a supervisor 7 different times, and then there are a number of others which indicate a kind of a negligent or maybe a bit of a nonchalant attitude toward importance of the job. But you don't get that same sense of repetitiveness in the record as far as Ms. Aquino is concerned. So it's not just the number of infractions, it's the nature of the infractions and the repetitive nature of the infractions that give me some cause for pause. You see what I'm saying?
Well, Your Honor, if I may, I'd like to address your concerns. First,
sure.
I think that you cannot claim that, not you personally, but it cannot be claimed that Amy Aquino and Mr. Tinsley are not comparators, simply because the department responsible for initiating charges of wrongdoing decided that it would not initiate those charges against Aquino. And what I was telling you wasn't some tit-for-tat behavior between Mr. Tinsley and Ms. Aquino. It was all one-sided. He was not harassing her. He was not showing up at her places of recreation and stalking her. She was. And he complained so much about that. Nothing was done. So he went down to Mecklenburg County Courthouse and filed a domestic violence protective order against her. The city of Charlotte hired an attorney to go down and represent Aquino on that charge. And they worked out a settlement agreement where she agreed to cease some of her behavior. Now, I believe that conduct, the conduct which gave rise to the need for a domestic violence protective order, is certainly the kind of conduct which constitutes numerous rule violations, but you never saw IA initiate any such rule violations. So when I say to you that the Internal Affairs Office did not treat the pleas and cries of Mr. Tinsley the same that it did a female who we strenuously contend lied when she alleged that he had raped her on April 2nd. She did not bring the charge until May 7th, which was the same day that she got a write-up. She went and told a coworker that she had been raped. That coworker was bound to report that, and he did make a report. And it was her report that the rape occurred on April 2nd between 2 and 3 o'clock. And Judge, you talk about a short texting period. It wasn't a text. It was a telephone conversation for more than 21 minutes. And then another 10 or 20 minutes later, another phone call to the same man. The jury heard that evidence and decided that she was being treated better and differently than Mr. Tinsley. And not only that, Your Honor, but this patrol officer, this sworn officer, made it her business to not only harass Mr. Tinsley, but to harass women with whom he had previously had relationships. She did that by following them. Mr. Tinsley reported it because the women called him and complained. She did that by calling one of them and threatening and saying to her, I know where you work, where you live, and I know where your children go to school. That was reported to the Internal Affairs Division, and no investigation was started. In addition, she ran reports on driver's licenses and automobile tags on women with whom he had previously had a relationship. That too was reported to Internal Affairs, and they did nothing to address that behavior. So there were things that piled up, behavior that piled up. And I am saying to you that if the Internal Affairs had treated Mr. Tinsley's complaints with the same care that they had treated Amy Aquino's, she would have a much longer and more serious record of discipline. This is why I say the Internal Affairs is at the core of this. And, Your Honor, she displayed lack of candor and truthfulness issues not only on the rape, but she also demonstrated that
Ms. Sumter, may I ask a question? One thing I'm wondering is a lot of what you're saying has to do with their private relationship and the fact that they are obviously in a very tangled relationship, and it's difficult to sort out. But I'm wondering what bearing their private acrimony has on the police department and the records of discipline, and that may have those kind of quarrels are sometimes best settled with a protective order. Sometimes they're best settled in a divorce court. Sometimes here they are best settled in a slander suit. But where the disparity lies are not in their private acrimony and recrimination, but in their professional behavior, which it would seem to be the chief concern of the police department. All of these infractions that are documented in the record have to do with behavior on the job, and the way in which the police department interacts with the public, or the way in which tardiness for work and the like makes the department's mission and functioning more difficult. And it seems to me that a lot of what you're talking about is private behavior, which doesn't impact relationships with suspects or victims or internal employment, punctuality and absenteeism. And I don't know how to sort through, who's raping whom and who's stalking whom. I don't know. I do know one thing about the rape, and that is the alleged rape, and that is that the testimony about it was very inconsistent, and that would take it out of the realm of the private, purely private. But if you say on the one hand that it was consensual, and then you get in a hearing and say, no, she told me to stop, that would take it out of the private realm and actually reflect on somebody's veracity. And you say, well, that person's word may not be trustworthy, and of course you want police officers testifying in court who are trustworthy. And as I understand it, the result of all of this, he was going to be slated for desk duty. But so much of this seems to me a sort of he said, she said, sort of very messy, sticky, private situation. And shouldn't we just be focusing really here on professional misconduct and professional behavior? Because messy situations, often take place off hours. And there are a whole lot of people whose professional conduct may be exemplary or may be deplorable. But we try to draw a certain line between the people's private business and their performance on the job. I'm trying to struggle with this case too, and I just want to raise with you some of the problems I'm having.
Thank you, Your Honor. I'd like to address them. First, all of the things that I just mentioned to you that Ms. Aquino did were done while she was in uniform and on the clock. So one of the things that she did was she showed up at the workplace of a woman that Mr. Tinsley knew in her uniform and stood and watched her, and then ran her tag. That was all during the course of her work and on the clock. All of that was unprofessional, and that was directed not at Mr. Tinsley but at other people. That's not a personal vendetta or a personal argument between Mr. Tinsley and Ms. Aquino. And I don't doubt, Your Honor, and the record is not clear on this, but I don't doubt that there were times, no, the record is clear on this, it's undisputed. And Mr. Tinsley testified that there were times that he and Ms. Aquino did not see eye to eye on where their relationship should go. That's not an issue in this case. That's not the issue in this case. And it's not, Your Honor, what spits and spats they may have between themselves. What is at question here is how the department addresses complaints brought to it, or whenever they find out that there is a potential rule violation. That's what we're bringing to this.
Ms. Sumter,
yes.
Sumter, this is Judge Keenan. It sounds like
Yes.
where you're headed then is to saying to us that as a matter of law, a reviewing court must consider uncharged conduct as well as charged conduct in making the determination whether somebody is an adequate comparator. Can you point to any of our precedents that has such a discussion of uncharged conduct versus charged conduct?
Well, Your Honor, I believe every case that you have where, I can't do it in the context of an internal affairs or a police department, but I believe every Title VII case where a plaintiff alleges that he was disciplined for something and someone outside of the protected class was not disciplined for the same thing would address that.
Okay, but this is different, I think, because what you're saying, and again, I'm not being adversarial, I'm just trying to understand this. You're saying that uncharged conduct of a different nature must be considered as well as charged conduct of a different and similar nature. So to what extent does the law require us to consider uncharged conduct of a different nature? In other words, stuff that she was doing on the job, stalking his girlfriends, that was not implicated in any way in terms of their disciplinary history, either one of them. Is it relevant? I'm curious on your take on that.
I appreciate your question, Your Honor. If the defendant maintains that it looks at the cumulative record when assessing discipline, and if the defendant is saying that Amy Aquino is not a comparator because her disciplinary record is not equal to or similar in material respects to Mr. Tinsley, if there's evidence in the record that she engaged in conduct which would amount to rule violations, but because of the discretion that the IA has, it decides not to bring them, then that is a difference in treatment. And that's what I'm talking about when I say this case is about how the defendant administered its policy. If IA has the discretion to shove things under the rug for some people but not for others, then I believe that that conduct is evidence of animus. And because the chief of police, when he makes the ultimate recommendation to the Civil Service Board, has no personal knowledge, has not done the investigations, he says. He's only relying upon the information which comes to him. So if IA is selective in what it charges and who it charges, then that becomes a question for the jury on whether the comparators are similar. That's the case law. Whether the comparators are similar is a question of fact. And the evidence was submitted, and the jury found that she was similar. And not only, Your Honor, if I could address a part of your question and a part of Judge Wilkerson's question. In addition to those things that I told you Akina did not get charged for, there was this slander trial that Mr. Tinsley initiated. Now, the city, if this were purely private, Judge Wilkerson, the city would not have a basis for hiring a lawyer to defend her and for paying the judgment that was rendered against her. She was sued only in her individual capacity for her slander with respect to the allegation of rape. But the city defended that action, even though itself had not come to the conclusion that a rape had occurred, and no criminal investigation was started, but they didn't even bring criminal charges against them. So when we look at a police officer who, in her personal capacity, is sued, but the city supports her with an attorney and then pays a settlement, but never charges her with a truthfulness violation after a jury has found her to have slandered. She is allowed to
in court.
I beg your pardon, Your Honor?
Aquino's still permitted to testify in court?
Not at this time, but if I may lay the facts out for you on that, Your Honor. The trial...
All I'm saying is that it wasn't something that they just overlooked.
No, Your Honor, please, let me explain to you. In 2014, the complaint for slander was filed. In 2016, the trial was held. The department claims that it supported her with a lawyer and paying the settlement because they said they required her to testify. I want the court to understand that that is incorrect as a matter of record. In the trial transcript of the testimony of Captain Rosalind Maglione, I asked her on cross-examination whether Aquino was required to give information in a criminal investigation, and her response was she was asked to give information. And I said she was not required, and this is on page 652 of the record. She said, I didn't have anything to do with the criminal investigation, so I don't know. And then my question was, but is the person ever required to participate in a criminal investigation? And her answer was, no, they are not. So even with the city acknowledging through her testimony that the reason that they proffer for giving this woman a lawyer and paying the settlement is contradicted by the IA captain. The jury heard all of that and could easily conclude that there was a difference in treatment. So the verdict came out in 2016. Clearly, IA and the chief of police knew that verdict came out in 2016. the procedure is that when an officer has a truthfulness violation or some behavior which impugns their credibility, the information is to be shared with the district attorney so that the district attorney can meet its Giglio obligations. That was not done in 2016. Only in November of 2018, or in the fall of 2018, did the district attorney gain knowledge that a jury had determined that she slandered Mr. Tinsley. November 2018, he wrote a letter to Chief Putney saying to him then that he could not call Amy Aquino to the stand because her credibility was jeopardized. He noted that she had already had one allegation of false testimony, which created some problems for her. But in this letter dated November 26, found on page 1371 of the record, he says, nevertheless, this fall, I was informed that a Mecklenburg County jury found Aquino liable to slander in 2016, and the city of Charlotte paid $41,500 to resolve the claim. In light of this new finding, I have concluded that the Mecklenburg County District Attorney's Office will no longer be able to call Officer Aquino as a police witness for the state of North Carolina in any criminal or traffic case. Amy Aquino. Yes, Amy Aquino. That's not the full answer, Your Honor.
I know, but that's the point one about him. It's the same way he said about him. He couldn't be a police officer, and you just read in the record the same type of thing. Go ahead.
Just correct, Your Honor, but that's not the complete answer. The complete answer is that when we tried this case in March of 2019, the undisputed testimony was that Amy Aquino was still working in the department as a patrol officer. So the chief of police shows up at the Civil Service Board and beats the drum about integrity and truthfulness and Mr. Tinsley being of no use to the department, even if the Civil Service Board had told him that he needed to be reinstated. He said he would make him a clerk. Mr. Tinsley has never worked as a clerk, and so reinstating him to a clerk would be defying his rights to reinstatement if the Civil Service Board had done that. Now, I ask you to consider the evidence, undisputed evidence, of Major Barnes about the relationship between the Chief of Police and the Civil Service Board and how they bend to the Chief's wishes to understand why the jury could conclude that all of this going on about truthfulness is really undercut by what this department did with Amy Aquino. These are all professional issues, Judge Wilkerson. That's not a personal issue. That's all a professional issue. Chief Monroe claimed that truthfulness was really critical, but the record, and I set them out in our brief, shows that there were a number of other officers who had truthfulness violations or should have been charged with truthfulness violations.
Okay,
and they were never.
Ms. Sumter, Ms. Sumter, this is Judge Keenan. I think you got to stay with this case.
I am, Your Honor.
Because we're having very extended arguments in this case, and I just want to make sure you're keeping us on track. And if you're talking about other officers, how are you helping your case?
How I am helping the case, Your Honor, is giving you the evidence that the jury heard, which allowed it to reach its conclusion on pretext. So the evidence is that the chief of police basically said that the real reason that he couldn't use Tinsley anymore was for truthfulness violations. And so I've shown you that the department undercut its articulated reason with respect to truthfulness as it handled Amy Aquino. But there was also other evidence that credibility and truthfulness did not carry the weight that the chief tried to impress on the Civil Service Board. And the jury heard that, and it reached a conclusion of pretext. And so we started down this road talking about who is the same actor. And as I referenced in my brief, once the jury gets all of this information, the question of whether Aquino was a comparator is a question of fact. The plaintiff has a burden on its prima facie case, which is not onerous, and it is not a burden of persuasion. It is a burden of production. Plaintiff's obligation for persuasion comes in at the pretext stage, and in this case, the jury found in plaintiff's favor on that pretext question. And there was ample evidence in this record upon which the jury could make that decision. And it is not for the court on appeal to second guess the credibility determinations or
I don't think it's correct to say that the question of similarity and comparator is invariably a question of fact. We have cases all the time where judges say, as a matter of law, there's simply not enough similarity or there's not enough comparability here to make out a prima facie case. It's just like anything else. You bear the issue. You bear the burden of creating an issue of triable fact with respect to similarity, as you would with anything else. And the question is whether you carried your burden.
That's what I meant, Your Honor, when I said the question of whether she was a comparator is a question of fact. I understand that there are cases where the courts used to make that determination, but my understanding of the issue on summary judgment is that with respect to any issues of fact, that those genuine issues of material fact and whether Ms. Aquino was a comparator, I think, is one of those genuine issues of material fact. And the case that I cite, Your Honor, I grant you, there are two district court opinions. One is Imani versus Bolden, which is out of the Eastern District of Virginia. It's a 2017 question. And it quoted a decision also out of the Eastern District of Virginia, which was a 2008 case. And I just want, Your Honor, to take a moment to say that the defendant relies upon the Mitchell case, but does not say to the court that the Sixth Circuit basically said that Mitchell has been clarified on the same supervisor requirement. And so in this case, because the chief of police claimed that he was the ultimate decision maker, he is the common denominator, because he would be the ultimate decision maker with any employee who received rule violations based on recommendations from IA. The other thing that I would like to add to address a question that was raised by you, Judge Wilkerson, is that, or maybe it was a part of the argument from opposing counsel, she said that Mr. Tinsley only did well at what he wanted to do. The record does not support that at all. There's no such evidence in that. I want to also tell you that with respect to Aquino, the opportunities for the department to hold her accountable for her behavior that was done while she was in uniform and on duty is evidence upon which a jury could do a comparative analysis and determine that she was treated differently under similar circumstances as Mr. Tinsley. Now, if all of this, to use your term, Judge Wilkerson, mess with this allegation of race had not occurred, Mr. Tinsley would not have been at the point where he would have been terminated. And if the jury heard the chief of police shout up and down about credibility and then saw all of this other evidence where credibility apparently did not matter that much, because in those other cases there was so much more egregious conduct, just flat out lying. You know, sometimes Mr. Tinsley was, for instance, accused of saying different things at different levels of the investigation. And I will tell the court that if you looked at the record of the investigations and at the hearings, you will see that Mr. Tinsley vehemently denied raping Ms. Aquino. And he also answered the questions that were asked of him. Different questions were asked of him at the at the command chain of command review board than Sergeant Burke asked. Sergeant Burke testified that there are times when in the investigation of a complaint, they find that officers change their testimony. And it's up to them to decide whether they are going to charge them for doing so. His actual testimony was that sometimes a falsehood is not actionable, even though they know that it is false. And so I'm trying to impress upon you this very wide discretion that the Internal Affairs has to target people and to take actions based on what they want to do, rather than to use the same standard with everybody. Now, the jury heard this evidence, and it saw that Amy Aquino was given the benefit of the doubt, that the department took her allegations very seriously, but that when allegations were made against her, not just by Mr. Tinsley, but by those women who received a threatening phone call and whose records and on whose jobs she showed up. Now, they didn't personally make the complaint, but they passed that information on to Mr. Tinsley, who did. No action was taken against them. And I cannot believe that it is not equally offensive to the smooth and efficient operation of a police department to have a police officer make threatening phone calls to a citizen, or to follow a citizen on her job for no law enforcement related reason. That cannot serve the interest of an efficient police department. Now, I believe that I heard a question about the amount of front pay. I think, Judge Wilkerson, you asked that and said that you wanted to have that addressed. If there are no other,
think it's been covered by both briefs. That's why I refrained from asking about it.
Okay, all right. And so, Your Honor, at this posture, I believe that the record evidence adequately supports the jury's verdict, adequately supports the judge's decision to deny the motion for retrial, and we ask the court to affirm the decision in all respects, including the jury verdict, the equitable relief, and the award of attorney's fees. I'll answer any other questions that the court has.
Thank you, Ms. Sumter. Ms. Keegan, you have some time reserved.
Yes, Your Honor. I'll just be, we've been going a long time. Just briefly want to address the issue of the standard that came up. I would agree with Your Honor that this court could find as a matter of law there was not enough similarity between Aquino and Tinsley, and even if the court were to wish to decide it as a matter of fact, that likewise could occur. The court could decide that as a matter of fact that there was not enough similarity, and that is pursuant to Moore v. Charlotte, which is cited in my brief. Secondly, I want to bring up the fact that as much of our discussion today has been about looking at the evidence, and so one of the remedies we've requested is a motion for a new trial. And in ruling on a motion for a new trial, this court is permitted to weigh the evidence and consider credibility under Wyatt v. Interstate and Ocean Transportation. So I just wanted to point that out. Ms. Sumter has brought up the fact, this notion that the city did not address complaints that were made against Aquino by Tinsley. And I would just want to briefly point out to the court that I believe the record before you speaks otherwise, specifically, one of the things that is actually listed about Ms. Aquino is a memo that is in her file that is before you in the joint appendix, and it is a very specific memo at the joint appendix at 1350. It's a memo that was put in her file from Captain Harris dated 5/7/13, and it's very direct, and it says effective immediately. You're given a direct order, to stay away from the Central Division. And it lists out different things she is not to do, and it says we will meet to discuss this further, if you have any questions, blah, blah, blah. But that was a direct result of a complaint made by Officer Tinsley. So that would certainly go against the notion that his complaints about Ms. Aquino that were made were ignored. I also believe there's testimony in the record that...
Did Internal Affairs investigate it?
In that case, that was not it was just a direct order made to her to cease doing something at that level.
Did the Internal Investigation Affairs deal with the other complaints about stalking?
To my knowledge, the testimony is that it was dealt with at the division level. So it never had to go to Internal Affairs because he reported it to his division head, and they investigated it. So that was what I was about to say, is that the testimony given was that different things are dealt with at different levels. In that regard, when he mentioned it to Sergeant Burke, he said, I've already reported this to my division head. And so I believe
that's the problem with this case. I mean, first of all, you have to ignore incredible decades of American history in this case. Decades in terms of context of this case. Because when you talk about comparative, most of those cases you're talking about, they're dealing with performance of the job. Obviously, when you're dealing with a comparative, you have to have someone, a supervisor or a department that's dealing with the same type of activities and performance and those things. That's not this case. You have to close your eyes to the facts and say otherwise. This case is about internal affairs dealing with conduct between these two people. This is not, you can bring up the record, his record since 1989. It had nothing to do with it. It all boils down to what they said. We can't trust this person anymore. It's a question about whether we can use him because of what he did in terms of responding to this investigation. So all this other structure you talked about, Attorney Sumter was absolutely right. It had nothing to do with, it's not about smoking mirrors in terms of comparative. The comparison is how you dealt with the two of these people with this investigation about this situation. And you get and they are common. The same person did it, the investigation, and the chief was the connector, and to that, and they were there. You didn't say anything about what Ms. Sumter said was wrong about the record. So all this stuff about other records, and also I can't believe the law is that you can ignore things that the other person's done that was never charged. And
well, I don't necessarily.
We have cases all the time where people. One of the biggest problems with racial disparity is that sometimes other people don't get charges. That's why your record is so replete with charges. If that was the law, you say, "Oh no, there's no difference." That's because you write me up for everything and write other people up for nothing. If that was the end of it and says a matter of law, we could say, "Well, you're not a comparator because you had 29 and this person had 3." That's because you haven't written them up. You haven't investigated them. That's the whole point. You say we can come as an appellate court and reverse the jury and the trial judge. The jury is the one who got the common sense of it and understood this case. And the question is, would they really fire him because of the situation between the two of them and how they dealt with them differently? And those are factual questions. There's no comparison based on any labyrinth you have. Because you would agree, no supervisors came up and testified about his being fired. This was all about the internal investigation. Let me ask you this question too. Before I end, did you tried the case, right? Don?
I did not.
You didn't try it. So unfortunately, but you're responsible. You're the only person I can ask.
Sure.
When they put in the record an interview that Sergeant Burke had with Ms. Aquino on May 17th, talking about whether or not she had gone through the parking lot, I don't like the name commercial place, but where she worked, and looked at license plates. It said that they put that in and said that she looked at a bunch of them, and that's how she got the plate. So she ran several license plates. You remember that? That's in the record?
Yes.
And didn't she say she ran that? Because the question was like, how did she get her information just because I was running several plates? Did she say she had run several plates? In that testimony that the Charlotte Police Department put on in front of the jury?
I believe that my recollection was she'd run 2 plates, but I cannot swear to you what she said. I don't recall it being several.
All right. Are you aware that she is in the record that other interviews she gave to Sergeant Burke?
I'm aware that she was disciplined for the same thing in terms of I know that she was disciplined for running a plate as well, just like he was.
But no, I used to be that she had given an interview before the one you put in evidence.
I'm aware of the fact that, yes, I'm aware that she spoke with them ahead of time.
Right.
Yes. Mm-hmm.
But
yes.
So you're aware of that, right?
Correct.
Now, you put in the one that was May 17th, but not the one that was earlier, that dealt with the whole question of how many plates she ran.
So
That's going to, I think, will be important in terms of, I think, whoever writes this case in terms of the record. You were aware that she had given an interview with Sergeant Burke before the one that you put in. You put on the one May 17th.
So I'm not aware that there was, and I'm not aware that there was one that was omitted. I thought that Ms. Sumter wanted
I didn't say omitted. I didn't say omitted. I know that's your word. I said it was where that it existed. I didn't say about omitted. I didn't say anything about omitted. I'm asking you, were you aware that it existed?
I was aware there was an interview before, but I thought he had a conversation with her before they went on the record, and so I was not aware that anything was left out of the record like that. No, I was not aware of that. So, but in conclusion, if I can just finish up, I know my time is almost up, but we are just asking this court, Your Honor, to give consideration to the fact that there was not a proper comparator here, and to also consider the fact that the awards of front and back pay are excessive under the circumstances, and to take into consideration the fact that he was offered reinstatement, and to likewise consider the issue of attorney's fees as set forth in our brief. Thank you for your time.
Excuse me, Your Honor. I know that, Your Honor, I know that I don't have rebuttal, but I just listened to your question.
Counsel, because we've gone so long, you'll have to do a 28J letter if that's appropriate.
Thank you, Your Honor. I can do that.
Unless my colleagues think that's allowed, to allow it. Judge Wilkinson and Judge Keenan, I assume this is something briefly you want to say about the record?
Yeah, and it's not an argument, it's just a fact. You are assuming that the defendant...
Wait, Geraldine, clear that up.
Before you say anything, Judge Keenan and Judge Wilkinson, should we do so or just refer to a 28J?
Whatever you prefer, Chief.
Judge Wilkinson?
I'm perfectly willing. Whatever you prefer, Chief, is fine with me.
But I'll tell you this, though. If you say something very pointed, I'm going to give Ms. Keaton an opportunity to very briefly respond, because that's not fair to her.
Yes, certainly, Your Honor. The only point that I've wanted to say is that your question assumed that the defendant entered those two recordings that you were talking about. Those were actually plaintiff's exhibits.
It was in the record. Oh, you put that in the record. Right.
Yes, Your Honor. That's all. Thank you.
Were both of them in the record?
Yes, Your Honor.
Both of them? Okay, good. That's all
yes.
I'm interested. So you put those in the
Thank you, Geraldine.
Thank you for clearing that up.
Yes.
I think that helped you.
I appreciate that, Geraldine.
Thank you. All right, counsel, we appreciate your arguments. We can't come down and shake your hands, but know that we're very appreciative of your good arguments and helpful in trying to understand these difficult questions, and we appreciate it, and we hope that you will be safe and stay well.
Thank you very much.
All right.
The court will take a brief break before hearing the next case.
Ooh.
Court of Appeals for the Fourth Circuit.
Mr. LaPierre, you may proceed.
Thank you, Your Honor. Good afternoon, peace of court. My name is Dallas LaPierre, and I'm here on behalf of the appellant, Lauren Varner. We are here today, Your Honor, on two disputed or appealed orders of the district court. The order granting defendant Michael Roan's motion for summary judgment as to plaintiff Lauren Varner's claim for an unlawful seizure, as well as the district court's order granting motion for summary judgment of Michael Roan on Mr. Varner's claim for illegal search of his truck. Addressing the first order, Your Honor, I believe we have a fairly straightforward issue in front of us, which is that the district court simply failed to consider consider true facts at this litigation stage in the light most favorable to the plaintiff to determine that those facts did not plausibly suggest a claim for an unlawful seizure. The facts of the issue, Your Honor, are fairly simple. Mr. Varner was in the tailgate bar and grill having a meal, having just been released after having been arrested by Michael Roan on another case. Mr. Varner's, in the middle of Mr. Varner's meal, Michael Roan entered the establishment, marched directly to Mr. Varner, ordered him to grab his coat and exit the restaurant. Upon exiting the restaurant, Michael Roan ordered Mr. Varner to empty his pockets, which Mr. Varner did. Upon Mr. Varner emptying his pockets, Michael Roan then, without permission or consent, pat-searched Mr. Varner, and again, finding no drugs or any weapons, advised Mr. Varner that he was now going to have a drug dog sniff around his vehicle. These considered true facts are clearly sufficient to plausibly suggest that a reasonable individual in Mr. Varner's position would not believe that he was free to terminate this encounter, but was instead under an individualized investigation for criminal wrongdoing. The district court analogized this case as close to the Drayton and the Monroe cases, and I think the court did that in error. In the Drayton case, Your Honor, that is Drayton v. Monroe, 536 U.S. 194, the officers in that case had conducted a routine drug interdiction on a bus. They had entered the bus and taken positions that they assured did not block the aisle or exit, quietly spoke to each individual passenger and advised them that they were doing a routine interdiction effort, and politely asked them if they would consent to a search of their person or their baggage. The issue in that case was whether or not the officers had to advise the individuals that they had a right to refuse consent, which the court did not, or ruled they did not need to provide. The court noted that the officers ensured that the passengers had a free aisle to leave, spoke politely, provided no command to answer questions or compel consent. And the issue there, Your Honor, was clearly that this was a generalized investigation of a consensual encounter or a routine encounter. And that is clearly distinct from the case at hand, Your Honor, where Mr. Varner was targeted individually and made to believe he was under the individual investigation for criminal wrongdoing.
Okay, Counsel, Mr. Prier, this is Judge Keenan. I'm a little bit concerned here because it seems to me what you're doing is making an argument that is not reflected in your pleadings. In other words, where are the facts in your pleadings other than command that indicate that there was a seizure here?
Yes, Your Honor. There's obviously the command to exit the building and to empty his pockets, Your Honor, but there's also the fact that there was an unrequested and unconsented to physical search. There was the presence of the officer.
Those facts, have you pleaded those facts that he did not consent?
Yes, Your Honor, we did. Looking at the complaint in this matter, I'm trying to find the exact paragraph number for you, Your Honor. It says specifically under paragraph 17, once outside said establishment, Roan commanded Mr. Varner to empty his pockets, and then finding nothing, Roan physically searched Mr. Varner. And there was no indication within the statement that Mr. Varner was asked or ever consented. And in fact, that is the allegation that he, by inference, did not, obviously, consent or was asked.
That's not what Judge Keenan asked you, she asked you, did you plead that it was done against his will, or that he couldn't refuse, or did you say that?
No, Your Honor, we did not.
Why did you?
No, Your Honor, we did not specifically plead that Mr. Varner refused, because Mr. Varner did not refuse. We did not specifically plead that he was not asked. Probably, Your Honor, I have to say to in our plea.
Did you plead that he felt that he could not refuse?
Your Honor, I do not believe we specifically pled that he felt that he could not refuse. We just pled the facts supporting that particular allegation in the facts section, Your Honor.
Isn't that a problem? You see, it's not just the fact that he did that. Police officers, they do that all day long. The question is, would a reasonable person have felt under the circumstances? You don't even plead that he did. He felt that way.
Yes, Your Honor, we were pleading the facts, and I do not believe we pled that.
You can plead state of mind for your client. That's not a conclusion. You say state of mind that he felt he commanded and he didn't feel he could refuse. You can plead those things. You didn't plead into that, did you?
No, Your Honor, we did not directly plead his state of mind.
All right, go ahead.
Of course, Your Honor. And the complaint does allege also in paragraph 35 that Officer Roan did demand to search Mr. Varner's body. And it is really the totality of the circumstances of Mr. Varner having been singled out within the restaurant, ordered to leave, ordered to empty his pockets, searched without consent, and then advised that they were going to run a dog around his car looking for drugs that led him to believe he was being individually targeted. This is much closer to the case of U.S. v. Jones, Your Honor, where an officer followed an individual's car with out-of-state tags into a private parking lot on an apartment complex. Once the individual had parked, he pulled further up the one-way street such that his car blocked their exit should they have attempted to leave, exited the car, immediately singled out the driver of the vehicle, walked up to him, asked him if he would lift up his shirt to confirm there was no weapons, asked if he minded if he searched him, and at that point the court held that this was a seizure because it lacked all the traditional hallmarks of consensual encounter. Specifically, it was not a routine encounter, but one targeted at Jones, and that the officer's repeated intrusive questionings created the impression within Jones that he was being subject to an individualized criminal investigation of his wrongdoing, and as such would not feel free to terminate the encounter. Those facts alleged in this case plausibly suggest that discovery would produce evidence that a seizure of Mr. Varner occurred under these circumstances without any lawful purpose. And the district court simply failed to consider those facts sufficiently in granting the defendant's motion to dismiss. Moving your honor to
your argument is that all reasonable inferences at this point should have been drawn. That your best argument that there's a reasonable inference that he was ordered and he did it, that he didn't consent. That's your argument?
Yes, Your Honor. The reasonable inference is that he did not feel he was free to terminate the encounter based on those previously stated facts, which was not drawn in his favor. Moving, Your Honors, to the second order in this case, the order granting summary judgment to the defendant on the claim of unlawful search. In this case, the court failed to consider the facts in the light most favorable to the plaintiff, drawing all reasonable inferences in his favor again, when the district court conducted a credibility determination and favored the testimony of one of the officers over that of Mr. Varner. Unfortunately, the incident in question was not audio or video recorded by any officer, nor was there any written report made. So the only evidence we have in this case is the testimony of the individuals involved, namely the testimony of Lauren Varner, the testimony of Michael Roan, and the testimony of Officer Johnson, the drug dog officer in the case. Officer Johnson testifies that he ran the drug dog around Mr. Varner's car. Outside of the view of anyone but himself, he alleges that the dog pressed his nose against the side of the vehicle, which was the alert. He then notified the other officers that there was an alert, and Mr. Varner's vehicle was searched. Mr. Varner, on the other hand, testifies that he was standing next to Officer Roan. They were both silently watching the drug dog run around the vehicle. The drug dog ran around the vehicle multiple times, each time veering off to jump on the back of the police vehicle. And on the final time around the vehicle, Officer Johnson slapped the hood of the vehicle. The dog jumped at the point where the slap occurred, and that Officer Roan then turned to Mr. Varner and advised him, the dog is cued, I now have probable cause to search your vehicle, hand me your keys, which he did, and a search occurred. Mr. Varner testifies that Officer Johnson did not hear Officer Johnson at any time alert anybody that there had been an alert during the course of this event. The district court stated that it was disregarding Mr. Varner's testimony because he did not have the expertise to determine what was an alert, and that Officer Johnson's testimony was not directly contradicted. And respectfully, Your Honor, I disagree with the district court on this point. Mr. Varner is stating the facts as he saw them, and if he is standing right next to Officer Roan and he does not hear or see Officer Johnson give anybody an indication that there has been an alert, but he does see what he believes, or he does see the officer slap the car, the drum, and Michael Roan declared that an alert, which gives him probable cause. Those facts, while not direct evidence, are circumstantial evidence that contradicts Officer Johnson's testimony. There is no other evidence but the testimony of the three involved, and so it comes down to a credibility determination between the three affidavits, the three testifying individuals, and that is a determination that is classically for the jury.
Why wasn't Johnson a case?
I'm sorry, Your Honor, I missed part of your question there. What was that?
Is Johnson even a party to the case?
No, Your Honor, Officer Johnson is not a party to the case.
Why not?
I believe when it was originally filed, Your Honor, we did not have the information that Officer Johnson was the person who had conducted the drug dog search. Our understanding was it was another member of the Skyline Regional Drug Task Force. Through the course of discovery, Officer Johnson was discovered to be the officer in question. And we simply did not, at that time, elect to add him to this case. Going back to the issue at hand, Your Honor, the defendant attempts to assert that Mr. Varner is simply piling speculation on top of speculation in order to create a genuine issue of material fact. And our position is that is actually absolutely incorrect. Mr. Varner is testifying as to the facts of what he saw and heard, and those facts create a conflict between the testimony of the only witnesses to the incident that is for the jury to decide. The defendant cites to the Glynn case for the proposition that Mr. Varner's testimony is simply unsupported speculation that should be disregarded, but this case is significantly distinct from Glynn. In Glynn, the individual was offered his testimony that some parts in a Cretan case were defective. His opinion, however, was contradicted by lab tests done that passed the parts and by the plaintiff's own testimony that the parts, while they deviated from the standard, were no doubt good and that the customer was satisfied with them. And in light of the concrete facts that contradicted his testimony or his opinion, Mr. Glynn was disbelieved and his testimony was said to be mere speculation or opinion that did not support a finding of a material fact in dispute. In this case, Mr. Varner is testifying as to actual facts that he saw, the actions of Officer Johnson, the actions of Officer Roan, the actions of the dog, and his own actions. And those actions are not contradicted by any hard or concrete facts anywhere else in the record. The only contradictions are in the testimony of the witnesses, which again, the weighing of witness testimony and accrediting or discrediting of that particular evidence is a classic function for the jury. And I've reached the end of my time, Your Honor.
All right.
If you have any questions for me, I'll happily answer them.
Thank you.
Thank you, counsel. Thank you, counsel. Ms. Johnson.
Yes, Your Honor. Chief Judge Gregory, Judge Wilhelmsen, Judge Keenan, this is Carlene Johnson for appellee Michael Roan. The questions that were being asked of Varner's attorney as to what other facts are alleged in the complaint other than the word commanded is exactly the questioning that the district court had of the plaintiff's counsel at almost the outset of this case. The transcript is in the record. What other than the word commanded are you alleging are facts that support this being a non-consensual encounter? And I would point out that all this time later, a year after the case was litigated, after the discovery was completed, the deadlines had passed, the extension that the plaintiff's counsel got for discovery had passed, and we're here in the Fourth Circuit now in Varner's own opening brief, particularly at pages 24 and 25. Varner himself equates the word commanded with request. It's referred to repeatedly throughout, especially pages 24 and 25, that Mr. Varner was requested. So I would submit that even Varner acknowledges exactly what it was that the district court was querying way back when in this litigation at the outset with respect to the count 1 claim, acknowledges that there aren't any facts here that are alleged satisfying the Fourth Amendment implication that is fundamental to the claim count 1 is depending upon.
Is that a deposition? Is there a deposition you're quoting?
No, I'm referring to the opening brief in this court, the Fourth Circuit, the opening brief of Mr. Varner. If you look at pages 24 and 25 of that brief, Mr. Varner is using...
That's counsel's word. That's not... His word is by his pleadings that he says command unless there's a deposition or affidavit that says otherwise.
Well, we have, this is with respect to the motion to dismiss the count 1 claim, which was based on the allegations and the sufficiency of the facts alleged in count 1 for that claim. And so it comes down to a matter of what facts has the plaintiff alleged in the complaint sufficient to satisfy the elements of the count 1 Fourth Amendment claim. And the word commanded is what the plaintiff has pointed to as the fact with respect to basing their Fourth Amendment claim on that. And plaintiff, in their own opening brief in this Fourth Circuit, has themselves interpreted the word commanded as being a request, which only further supports that the allegations in the complaint are not sufficient to plead satisfaction of the elements of a Fourth Circuit claim to show that this was not a consensual encounter. And I would further point out just procedurally with respect to this case, 10 days after Michael Rohn filed a motion for summary judgment, which was almost a year after the case had been litigated and we'd gone through discovery and all the deadlines had passed, 10 days after Michael Rohn filed the summary judgment motion with respect to the count 2, the only claim remaining in the case, Varner filed a motion to voluntarily dismiss the case. Michael Rohn opposed that, having been put to the burden and expense of hearings and having to obtain court orders even to take the plaintiff's deposition as well as the other fact witness depositions, and having to make motions over the plaintiff's refusal to answer questions in his deposition about complaint allegations, and having already filed this pending summary judgment motion. And the district court, though she granted the summary judgment motion as to count 2, having already dismissed count 1, thought that the motion for voluntary dismissal by the plaintiff was moot. But the district court said that if she were to rule on the motion to dismiss, the dismissal would be with prejudice. And pursuant to Rule 41A2, the district court has that discretion. The Rule 41A2 provides that a dismissal of the plaintiff's request can only be by court order on terms that the court considers proper. And then coming into the Varner did not ask the district court to have his case go forward to trial. Quite the opposite. He wanted the district court to dismiss the case. And in fact, the reason that he gave was, and it's in the record, with respect to the motion to dismiss and the reply brief that Varner filed in support of the motion to dismiss, was that he wanted to add other parties to the case and have a whole new case that had everybody, all officers in it, but he never filed a motion even and sought to have it consolidated, didn't do any of those things. And so then now, having not asked the district court to let this case go to trial, Mr. Varner has now come into the Fourth Circuit asking that this case go to trial, which is not what it was he was even asking for in the district court. I would point out, too, I found it perplexing in the opening brief and in the reply brief that Varner has filed in the Fourth Circuit. In his conclusion, page 47 of the opening brief and page 8 of the reply brief, Varner only asked for a reversal of the summary judgment motion, which is a count 2 claim, and doesn't even mention in there asking the court to do anything with respect to the dismissal of count 1. The civil action requires the plaintiff to have alleged facts that are sufficient to show entitlement on the claim that he asserts, and they're elements of the Fourth Amendment claim. An unreasonable search and seizure by a governmental actor, and I submit, and the district court, I think, properly ruled that on no more facts than the plaintiff has alleged with respect to count 1, that he is not satisfied the elements of those claims under the applicable pleading standard, and dismiss it. Now, the district court dismissed it without prejudice, but the plaintiff never amended, never sought to amend, not at any point during discovery, not at the conclusion of the discovery, at any point at all. I think that the court did not err in that dismissal, and that it should be affirmed. With respect, and there are a couple, I'm sorry?
So you're saying he didn't plead enough when he said that the officer walked?
He didn't plead facts that are sufficient to satisfy the elements. And in fact, the number of, I won't go through, I think the plaintiff's counsel has misrepresented what some of the factual allegations and added things like marched directly to Varner and some other things I heard that are not anywhere in this complaint. Also, there are other things in the complaint that further show a reasonable person in Varner's position would know that he could refuse, that his liberty was not being restrained, that he could terminate the encounter, because in fact, Varner did. When he was asked to take a breathalyzer test, and he's alleged in the complaint as being in a bar and for a drink and to eat, and there's also a heading in the complaint actually that refers to a DWI, that Mr. Varner refused. And he said he refused. He knew he could terminate the encounter, and that further shows that not only would an objectively reasonable person in Mr. Varner's shoes know he could terminate the encounter, but Mr. Varner himself knew that. He did. When he didn't want to take a breathalyzer,
he left the scene, did he not?
He left, and the officers left. It was a non-event. They went on their own ways, only further showing that an objectively reasonable person in Mr. Varner's shoes, and in fact Mr. Varner himself, viewed this as something he could leave if he wanted to. It was a consensual encounter. There were no facts showing that it was coercive in any way, and no facts that the court has sometimes looked to, and I'm thinking more recent cases, and while in the criminal context, and I think that's a distinction here too, because of course in the civil lawsuit, Varner bears the burden of alleging facts sufficient for his pleading obligations, that there are no allegations here about any sort of intimidation, racial profiling in a disadvantaged community. There's no blocking in of a car so that Mr. Varner can't exit or leave or go on his way. There's no uniform. I'm sorry?
Isn't the putting here that he actually, is a question of whether he felt free or not to leave? He actually exercised his right to leave. He refused to take the breathalyzer test. He left, as you say, they went their own way, and that was that. And given the fact that he not only felt free to leave, he did leave. He actually left. And he wasn't pursued. He wasn't restrained. That's that. What more is there to say? I
will say nothing further. Move on to the summary judgment claim, unless unless anyone has a question for me with respect to the count 1, which was dismissed on the pleadings. Okay, so the count 2 claim has to do with the search of occurred after a free air drug dog sniff. Drug dog Zeke that was being handled by a canine officer from a separate agency, the City of Waynesboro Police Department. In his opening brief, Mr. Varner agrees that drug dog Zeke alerted to Varner's truck. Mr. Varner states that it's uncontested that as a result of this dog alert, Defendant Roan asserted he now had probable cause to search Mr. Varner's vehicle. Mr. Varner acknowledges that a drug dog's alert can provide probable cause for a search. Mr. Varner's only argument is he says he disputes whether or not the alert was manufactured.
Again, Johnson's not even a defendant to begin with. And the idea that he manufactured some kind of positive alert, there are no facts to support that. It's total speculation. I mean, he talks about whether Roan heard Johnson report the alert or whatever, whether he heard it or what, that's not even really relevant. But he's making a claim against a non-party that the non-party manufactured a positive alert. There's nothing manufactured about it. The dog, who was apparently some kind of superstar, and Johnson had a long relationship, and as far as we know, the dog pressed his nose against the car and pointed his feet, which is what the dog usually does. I know it's just, when you look at the record here, it doesn't suggest any kind of manipulation or manufacture. So what else is there? What is there to add?
I don't know that I have anything to add. I think that's correct. It's not a credibility issue, as Mr. Varner wants to represent it to be. It's a matter of having competent evidence. And Rule 56 itself refers to someone having to be competent to testify on the matter stated. The only competent evidence here is that this canine officer and his dog, they are certified by the Virginia Police Canine Association. Their training records, in fact, they had passed the most recent training for certification just in November of 2016 before this incident, which was in January of 2017. So just in the last 2 months, we're in a controlled environment. Zeke had 100% accuracy. He found all of the drugs he was supposed to find, and they didn't have any false alerts at all. And Mr. Varner's attorney made reference to the canine officer having done this free air sniffed in a place where only he could see, as if there was something secretive to that. That's not accurate. The dog.
Go over all of that in your brief, and quite rightly, I think, because this idea that he manufactured, there are no facts in this record to support any such claim. There just aren't. So
that's correct.
I don't know what more there is.
I'm sorry.
I don't know what more there is to say.
I would address this other aspect that Mr. Varner has tried to make it sound secretive on the part of the canine officer or someone. Mr. Michael Roan himself testified he didn't recall which officer told him the dog had alerted. The evidence shows that Michael Roan and Mr. Varner were standing next to each other about 50 feet away from where Mr. Varner's truck was. The canine officer was handling the dog. They were going around the perimeter in the public parking lot of this vehicle. The dog was alerting on the passenger side door. which is on the other side of the vehicle from where Mr. Varner and Mr. Roan were. That's not something secretive. That's where the dog was alerting. He was alerting by pressing his nose against the door and kept his feet on the ground, which is what his alert is, according to his training and his experience and his canine officer working with the dog. It's all laid out in the evidence. Mr. Varner and neither Mr. Varner nor Mike Roan could see that side of the truck or the door, but there's no dispute that the canine officer reported the alert, and in fact the recording of his call to dispatch reporting the positive alert at the tailgate parking lot is part of the record. One of the other officers, two of the other officers were other places in the parking lot, and Michael Roan didn't recall exactly which one conveyed to him that the canine officer's dog had alerted and that the canine officer had announced that alert. But there's no dispute that there was that determination by the canine officer based on his handling of this drug dog with which he's certified. And it's completely a reliable drug dog. That's all in the record. And of course, in any event, there is nothing here, not only no evidence that it was a manufactured alert, but certainly no evidence that Michael Roan had any reason to think that there was anything untoward at all about what the canine officer and the drug dog were doing and about the alert that was determined. And that does, under the well-settled law, provide probable cause for the search that followed.
The whole thing is some sort of ludicrous conspiracy theory. I guess I don't know who the conspiracy is between. Is it between Johnson and the dog?
I haven't had the pleasure of meeting Zeke, but he'll probably plead the fifth.
The evidence shows that Zeke is a superstar.
Whatever. He had 100% accuracy record in his training just 2 months before in a controlled environment. And certainly, I believe Chief Judge Gregory and Judge Keenan were also on this panel of the U.S. against Green case, in Fourth Circuit 2014, that talked about the reliability of a dog and a drug dog being based on its performance in controlled testing environments, spoke about the Florida against Harris case with Justice Kagan's writing for the unanimous Supreme Court that talked about the presumption that a dog's alert provides probable cause for a search, and the satisfactory performance in a certification or training program for the drug dog provides that reliability and that ability to rely upon that for probable cause for the search, and that's what we have here.
Thank you.
Thank you.
All right. Mr. LePere?
Yes, Your Honor, please, the court. I wanted to address a few issues that came up in my co-counsel's arguments on this case. The first issue I want to address is that there is an assertion that Mr. Varner felt free to leave at any time because at the end of the encounter, after Officer Roan had Mr. Varner's vehicle searched and had found nothing, and after he had been searched and there had been nothing found, Officer Roan asked Mr. Varner to conduct a breathalyzer test, and Mr. Varner declined. The assertion was that then Mr. Varner left the scene, and therefore knew the entire time he could have terminated and left the scene. However, as alleged, the facts are slightly different. It is that when Mr. Varner was at the end of all of this, having been searched himself, having had his truck searched, they asked him if he would take a breathalyzer. He declined. And then Officer Roan left, not Mr. Varner. Mr. Varner actually remained at the tailgate restaurant where he was. So that does not indicate somehow that he knew throughout the course of this that he was free to terminate the encounter prior.
Counsel, you're missing the part about he said no. And the point
yes, Your Honor.
I'm saying I agree with it, but you had to address that. It evidences that he knew he could say no, which is a refusal. And notwithstanding that the officer walked off, can you address that in response to, I think it was Judge Wilkinson's argument? Go ahead.
Yes, Your Honor. And the difference here is that Mr. Varner said no to something that he was for the first time asked to consent to. He was asked to take a breathalyzer test, and he said no, he was not going to do that. And that issue is completely different than...
That's a good point. It's the first time he was asked.
Throughout the course of this encounter, Your Honor, he was commanded to leave the restaurant. He was commanded to empty his pockets. He was searched with no indication that there was a request. He was told he was going to have a drug dog ran around his vehicle. He was told there was now probable cause, give him your keys. And then at the end, once all of this is done, he's had a thorough search of his vehicle. He's finally asked, will you take a breathalyzer? No, I'm not going to do that. I'm not driving. And then Officer Roan left. So that doesn't indicate that he felt through all of these commands that he was able to leave. The second issue is my co-counsel brings up that there was an allegation or a reference to these commands as requests within the pleadings. And that is very accurate. That is because in the pleadings, he was comparing these commands to the request in Jones. In Jones, the officer said, will you lift your shirt up so I can see if you're armed? Do you mind if I pat you down for weapons? And that was still found to be a seizure. And here, the complaint uses the word commands, but either way, repeated and intrusive requests, even at our actual request, that indicate an individualized investigation of criminal behavior by this particular person, leave a reasonable person subject to not feeling free to leave that particular encounter. And as the Monroe case makes very clear, an individual's subjective beliefs do not render a search consensual or unconsensual. In Monroe, the individual testified that when an officer approached him at home and asked him for a DNA sample as part of an investigation into serial rapes where everybody who fit the profile of the particular rapist was being asked for their DNA sample, he said, based on my belief of the relations between African Americans and the police in this community, I did not feel free to terminate that encounter. And the court said that your subjective beliefs are irrelevant. The other indicia, the objective indicia, are not there in that case. In this case, Your Honor, we submit that the objective indicia are there. Mr. Varner was repeatedly commanded to do things that were intrusive, such as emptying his pockets, submit to a search, leave his meal to go outside, grab his jacket, and then obviously to turn over his vehicle to be searched by a drug dog and then himself be physically searched. And that is vastly different than the case law in question that they are addressing. The second issue is that the concern is not that Officer Johnson, was being secretive about the search when we're set into the second issue at hand, Your Honors. The issue is that Officer Michael Roan, Mr. Varner, and the other officers on the scene were on one side of the vehicle. The drug dog officer asserts that the dog alerted on a side where nobody but him could see it. Despite the clear policy of his own police department, there is no body cam video of this event. There's no audio recording of this event. He does eventually report to his dispatch sometime later that there was a alert, but on scene, and that report to his dispatch does not include any indication of how, aware, or what the alert was. The only evidence is the individual's on-scene testimony of what they saw. Mr. Varner says he saw, in his deposition testimony, Officer Johnson run the dog around it, slap his fender, at which point the dog jumped. He says he never saw, and Officer Johnson did not advise anybody, because he could not hear, he could not see him make that advisement, and the officers were with him, that there had been an alert. That having viewed the dog jump on the fender, Officer Roan said, the dog is now alerted. I have probable cause, give me your keys. That is at odds with the testimony of Officer Johnson, which has no other evidence to support it other than his testimony. It may be unlikely, it may be unbelievable, but those are weighting of credibility of the testimony in the case that is for the jury, that Officer Johnson was untrue and Mr. Varner was correct. The issue is Officer Roan himself does not testify as to who told him or where he heard it, but he does testify quite contradictory to Mr. Varner that he was not watching the scene. And again, these distinct disputes of fact are material because they provide evidence that the alert, and the only alert that anyone was aware of, was the drug dog jumping on the hood in response to a slap, which is clear improper cueing of the dog, as according to the experts in the case, that would result in manufactured probable cause. And the case law is clear that you cannot search or conduct a warrantless search based on manufactured probable cause. I understand the dog is reliable, according to the evidence in the record, and nobody disputes that. The dispute is over whether or not the alert was cued by Officer Johnson, whether or not Mr. Roan saw that cue alert and knew it. And I'm out of time, Your Honors.
All right. Thank you so much for your argument, both counsel. We can't come down to shake your hands, but know that we appreciate very much your arguments here today, and wish you well. Be safe and stay well. Thank you so much, counsel.
Thank you, Your Honor.
You're welcome. And we'll ask the deputy to adjourn the court for today.
Yes, sir. This honorable court stands adjourned until tomorrow morning, or this afternoon, sorry. God save the United States and the